Good morning, everyone. The time is 9:30 and time to resume the inquiry. This is an inquiry relating to land south of Old Park Lane, Farnham. There's an appeal by Gleeson Land Limited in relation to an outline application with all matters reserved except access for up to 83 dwellings with various infrastructure. The application was refused by the council on the 23rd of August 2024. So just a couple of housekeeping matters before we proceed. I haven't received anything overnight yet, so I don't know if anything's been submitted by anyone, but my case officer hasn't forwarded anything to me yet. So there were various things that I asked for. Mr. Green?
Madam, I don't think anything's been forwarded to the inspectorate yet, except perhaps the updated allocations site delivery data. It's agreed, except for one site, there's a minor disagreement about how many dwellings are deemed to have been provided. That's explained on the sheet I'm going to hand up, but I think apart from that, all the other sites and the delivery thereon are agreed. So if I could hand that up.
Thank you, Mr. Green. Thank you. I'll mark this as inquiry document 11, which seems a bit back to front because really the agreed position would be better for that to be an update as 11, but I don't have it yet. It's not arrived, I'm afraid, so I don't really want to do that. So I'll have this as inquiry document 11.
Madam, regarding the conditions, I think there's a revised draft that's with the appellant at the moment.
Okay, so if that could be with me by the end of today,
yes,
that would be splendid. Otherwise, tomorrow morning seems like it's going to be a slightly prolonged event when it doesn't need to be. And also the 106, I still don't have. Mr. Lisson, you said what you were saying yesterday about the 106.
Yes, I think it's just that editing process hasn't yet been completed, but that's so there's no, as I understand it, disagreement about editing the references to Farnham Park out of the document.
Okay.
So that I think is in hand.
Okay, so could I have a paper copy? And
yes.
Even if the references are in it at the moment, and then I'm happy to sort of, for my own notes, strike them through.
Yeah.
But when I'm sat in my hotel room this evening, I'll have nothing to read if I don't have a nice paper copy. Section 106. Right, okay, so then there was the other documents that I'm still waiting for, which can, as long as they arrive, then that's fine, they just need to arrive, are the documents from Councillor Powell that she referred to yesterday and the Landscape Institute notes that were referred to by Mr. Litton and his cross-examination of Mr. Petro.
Yes, and I think they weren't sent last night, but they're going to be sent any second now to the case officer, so that they'll make their way to you.
That's super. Thank you very much. Something has been handed up. I haven't yet seen it. It's to do with the interested parties. Mr. Green has seen a copy. Mr. Litton hasn't. Who was it handed up by? Mr. Free? Yeah. Mr. Free, could you just explain to the inquiry what they are?
Representation, which were actually given yesterday, and I understood there were 3 copies needed. Some of the representations were one, so I copied them and gave you 3 copies.
Okay, so there are 3 copies here of each representation, right? Mr. Green, do you think someone from the council would be able to sort those out?
Yes.
So that Mr. Litton can have a copy of them?
Yes.
And then provided everyone's happy that they just reflect the representations that were made yesterday. Yes, I'm happy to accept.
It wasn't quite clear to me. Are these just copies of the physical documents that were distributed yesterday when there weren't necessarily enough copies for everyone? Or are these the transcripts of those who spoke yesterday but didn't hand out a physical copy?
That's a very good point. They're the transcripts.
So you will have so taking your own notes,
Yeah.
then you
I have both now.
You have both, yeah. yeah.
But yes, but if you'd just
Okay.
like to have a look at them and so that you're both happy, that that's what they are, and
Yeah.
then I'm happy to accept them. And I will note them as inquiry documents when they come in, and then I'll circulate a list to you both by the close of play, probably on Friday now, if I'm honest, with the inquiry documents that I have. Okay, right, splendid. So yesterday we heard the evidence of, lost my note. Thank you. Yesterday, we heard the evidence of Mr. Bell and Mr. Petro, and we heard the evidence in chief of Miss Eade. And so we are slightly ahead of schedule, which is good. We have a lot to get through today, but I'm confident that we can do it with a fair wind. So, Miss Eade, thank you for being here this morning. Does anybody have any housekeeping issues that they'd like to raise before we start? Miss Siddison? No. Mr. Green? No. In that case, when you're ready, Mr. Green, please carry on with your cross-examination. We'll start your cross.
Thank you very much, Madam. Good morning, Ms. Eade. In accordance with the inspector's instructions, I'm going to identify the core documents that I'm going to take you to, if I may. CD 1.22, which I think is the 2023 LVA.
Sorry. If you list them all now and then I'll get them.
Okay,
Yeah,
CD
yeah.
1.22, CD 1.40,
Yep.
which is the visual viewpoints, CD 2.15, which is the 2024 LVA, CD 5.1, which is the local plan part 1, CD 6.3, which is Glivia, CD 8.4, which is the landscape statement of common ground. And I may refer to the planning statement of common ground at 8.3, but I'm not sure yet.
I've got most of those, but there's a couple I haven't. Okay.
And the questions I'm going to start asking you about are concerned with the various iterations of the illustrative master plan and the visual viewpoints that we have, because I have to confess I'm a little confused, and I
Yes.
hope you can help me.
Apologies, yeah.
Yes. Starting with the 2023 LVA, so CD 1.22. That has, and I'm looking at the digital version, page 111. The verified views, the beginning of them.
That's right. Those are dated on that document.
Yes, May
as
2023.
May 2023. That's right. Yes.
And we have been referred to the visual viewpoints at 1.40. And again, I think that's a 2023 assessment, is it?
The 1.40 is the May 23.
That's what I have at electronic page 1.
Yeah.
So it's I think it's the same, is it?
Bear with me. Yes. I think, yes, yeah.
So that was the position in 2023, and then we moved to the 2024 LVA, which is at CD 2.15.
Yes.
And Appendix 5 to that has visual viewpoints again, and I'm starting at electronic page 157.
This is, yes, and that's the one that's wrong because that has the June 22 AVRs in it.
So that's wrong.
And my understanding, I apologize, I wasn't involved on the day-to-day matters at this point in the project, but my understanding was that that was noticed just before committee and it got substituted with the correct visualizations. But the inquiry document, unfortunately, she's got the earlier version that has the June 22 version.
Okay. If we go back in this document to digital page 6, paragraph 2.10.
Yes.
This explains that the 2024 version of the LVA was amended to reflect various changes concerning sustainable drainage, changes to parameters plan, illustrative master plan, and so on. We can see that in paragraph 2.10. Those changes are not reflected in the visual viewpoints we have at this inquiry.
I'm going to have to, I might actually ask one of my colleagues, because as I say, I wasn't involved in the planning submission, but my understanding is that the CD 1.40 it reflects those changes because they reflect the lower heights. Most of those didn't change most of them didn't change the scheme. So sorry, the March 2024 reflected the revisions to the drainage strategy. It was specifically the drainage strategy, and those didn't change the visualizations because it didn't actually change the 3D form of the buildings. So
It didn't change the location of the buildings?
I don't believe so.
Okay, well, can you check? Because as I understand, the visual viewpoints we have are dated, I think, May 2023.
Yeah.
There have been changes to the illustrative material, to the scheme, since then, including most recently your rebuttal illustrative landscape proposals. None of which is reflected in these visual viewpoints.
Well, obviously, I don't think they don't substantially, I don't think they, if anything, there'll be a few additional trees because we put some additional trees in, which is, you're right, it's not reflected. We wouldn't normally, that was a late change to the scheme. But the position of the buildings and particularly in relation to the surrounding features, hasn't changed.
I don't want to be unfair to you,
No.
and I obviously don't want the inquiry to be misled in any way. So can you check, just
Yeah.
to make sure,
Yeah.
that the visualizations we have from 2023
Yes,
reflect the current scheme before this inquiry?
yes. Is that something I can?
Yes, no,
I'll need to check with the colleague.
happy for you to do that outside.
I was made, that was what I was told before I went into the inquiry by my colleague, that was the correct version. So, but I can double check that. I understand there's confusion, particularly with
Yes.
that March 24 variation, but I don't think that changed the visualizations. But I can ask that question again, absolutely, and come back to you.
Good.
Yeah.
Good, thank you. Moving on, and I hope we can take this fairly quickly. Can you turn up the local plan part 1, CD 5.1? Just going to look through 3 policies, which you'll be familiar with. RE1 first of all.
Sorry, do you have a page number for that?
It's internal page 113. I'm looking at a hard copy, so I don't know what the digital page is.
So I prefer, yeah, fine, thank you. Yeah, I prefer electronic, actually. RE1 or RE3?
RE1, we'll go through them in order. RE1, please.
Yes.
And it says, within areas shown as countryside beyond the green belt on the adopted policies map, and that's this area, the intrinsic character and beauty of the countryside will be recognised and safeguarded in accordance with the NPPF. And we can agree, can't we, that the appeal proposal conflicts with this policy?
Yeah, I mean, I think there's a clearly the appeal scheme does recognise the countryside. There's a lot of mitigation measures that do recognise the intrinsic character and beauty of the countryside, and the scheme was specifically designed to recognise those. So there's a and to safeguard any features of, yes, there is a conflict, but I think there's been but limited, because the scheme has been modified to reflect that.
Well, obviously, there's an issue between us as to the extent of the conflict and the weight to be attached to it, but just wanted to be clear, we are agreed that this policy is breached by the appeal proposal.
Yes.
Yes, thank you. Hopefully, we can be equally brief then about policy RE3, landscape character, again, hard copy pages 127 and 128. You have that?
Yes, yes.
Good, excellent. It begins, new development must respect and where appropriate enhance the distinctive character of the landscape in which it's located. The landscape character area in which the appeal site is located, indeed the landscape character areas, because there are 2 assessments. They are landscapes characteristic of countryside. Is that fair enough?
Sorry, which we're not. So, you asked the question again, because there's a series of sub clauses, and we're the only one we're within is the area of strategic visual importance.
I'm starting at the beginning, which I think is a good place to start. If you have the policy, you'll see it begins.
Yes, sorry, I'm with you. Yeah.
Good. And so this is the broad thrust. You're right, we will absolutely go to Roman 4 in a moment. But can we agree that the distinctive character of the landscape in which the appeal site sits is a countryside landscape?
Yes.
Yes. And can we agree that the appeal proposals neither respect nor enhance that distinctive character, the countryside character?
Well, I would say there's a lot of respect has been given to the countryside, so I don't think I would agree with that. I think, as I say, the scheme has been landscape led from the start, and the specific qualities of the countryside have been respected, and so the way the scheme is laid out is respectful of those particular characteristics. So, you know, if you didn't do anything, you wouldn't get any development anywhere if you were to take the assumption that you can't change any element of countryside. So I would say that we have indeed respected it.
I think it's common ground, based on your own evidence, that the appeal scheme will harm the character and appearance of this part of the countryside.
Yeah, but I also say I think there's a duality there, because I think that because of the approach that's been taken,
The overall effect, nonetheless, will be harmful.
some harm, yes.
Yes.
Yeah.
And so, in
As one would with, as I say, with any development in the countryside.
yeah. And then going on to Roman 4, the area of strategic importance. It says pending a review in the local plan part 2, the areas of strategic visual importance will be retained. Well, that review has taken place and the area of strategic visual importance remains. It says the appearance of the ASVI will be maintained and enhanced. Proposals for new development within the ASVI will be required to demonstrate that the development would not be inconsistent with this objective. So if the objective is to maintain and enhance the appearance of the ASVI, we can agree that the appeal proposals will not comply with that policy.
Well, I cover this in my proof in quite a lot of detail. Is it worth me giving the inspector where I go to that? I think that might be helpful.
Well, if I could have just a simple yes or no answer to my question, we can agree, can't we, that the appeal proposals will not maintain and enhance the appearance of the ASVI?
There is limited, yes, there is limited conflict there, but I would urge the inspector to go to my proof to understand more the context of the ASVI, what its purposes is, and my opinion on that, which is covered in paragraph starting 2.42 of my proof. And in that I break down what the role of the ASVI is, and to what extent the site contributes to that and how it would be affected. So that's paragraphs 2.42 to 2.48. And the point I'm making there is that it's the elevated parts of the site where the development is not proposed, which are by far the most important in that terms of in creating that gap, creating that sense of openness. So it's the lower slopes where development is proposed, which is not visible in those cross valley views, that are less important, and it's those parts of the site where development is proposed.
I mean, as I said, I want to get a clear answer to the question, and I think you have said there's conflict.
There is some conflict, yes.
Yes. Thank you. Finally, if we can turn up, I think this is a document I failed to mention, the CD 5.5, the neighbourhood plan. And I'm looking at page 44 of the hard copy.
Yes.
Policy FNP 10.
Yep.
It starts by saying that outside the built-up area boundary is defined, priority will be given to protecting the countryside from inappropriate development, and it goes on to explain what that means. One of the requirements is that if there is to be development, it accords with other policies in the neighbourhood plan. That's A, and I think it's a matter of agreement that the appeal scheme doesn't meet criterion A. And then the last one, E, development should enhance the landscape value of the countryside. And again, I think it's common ground that it does not do that.
Well, yes, but well, there are elements of it that does enhance. You know, there's no doubt about it that there are enhancement measures within the scheme. So there's a you know, all the landscape proposals can follow the landscape guidelines for enhancement so for the areas where development is not proposed, there is enhancement, but for the site overall, there is clearly some elements that don't enhance. Yes.
Yes, yes. I mean, it's all very well focusing on the aspects of what you describe as enhancement or mitigation, but you've got to look at the scheme as a whole, and the scheme as a whole includes a housing estate.
That's correct. Yeah.
Thank you.
But you do also need to understand that with that housing estate comes the delivery of a large area of open space, the delivery of extensive landscape mitigation, the creation of community orchards, new planting, native planting, hedgerows, massive increase in BNG. So it's all part of that.
Of course, and the inspector will reach a judgment, her own judgment on the value of those matters.
Yes.
You say it's providing an open space. Of course, the site is an open space at the moment, is it not?
It's not a public open space.
Not a public open space.
It's fenced off arable grazing land.
With footpaths that both cross it and go round it.
Yes, but obviously there's much more public access being granted as a result of the proposals.
In terms of impact on landscape character, and for this, I'm going to take up the statement of common ground on landscape matters. So CD 8.4, please. Pages 10 and 11.
So is that PDF pages or?
No, sorry, I'm hard copy again. I'm old school.
There is a hard copy.
No, I'm all right. I thank you. Yeah.
Page 10 and 11 has extracts from the Surrey Landscape Character Assessment. Top of page 10, we can see the landscape character area considered there. And the appeal site is a relatively small part of that character assessment area.
It is, yes, yeah.
And we can see at 3.14, the assessment looks at the key positive landscape attributes of the entirety of that area.
Yes, yeah.
And there are a number of bullets there. The first is areas of peaceful rural farmland, and that aptly describes the appeal site, doesn't it?
Well, I would say it was urban edge farmland. It's clearly, you know, it's heavily influenced by the adjoining development edge. So, you know, I would say that you know, in terms of positive attributes, that part, I don't think that part of the site of the area of the character area is particularly, you know, it's the central areas where you experience of the character area where you have that really peaceful rural farmland. Because although, yes, the site itself is currently arable farmland, it's the character is influenced by the adjoining land uses, which are urban.
The appeal site is peaceful, isn't it?
It is less peaceful than the areas in the centre of the character area because you're next to an urban area.
It is, you've been on site.
I have been on site, yes.
And the inspector has been on site. One can go on site. It is a relatively peaceful site.
It's no more and probably less peaceful than most other rural areas in the area.
And it has...
Because peaceful is there's both visual peacefulness and oral, and, you know, in both senses, there is an urban area next to it that affect it.
Again, a matter of the inspector's judgment. The next bullet, network of hedgerows, hedgerow trees and field trees, one sees those on and around the appeal site.
Not generally in you know, they're remnant hedgerows, they're poor condition. Again, I'm looking at an aerial photograph of the wider area where that is far more evident and far stronger. So the hedgerows are not intact. They're very gappy. They're poor quality. There's few hedgerow trees. You know, the network is incomplete on the site.
Okay, an incomplete site or an incomplete network, that is, but nonetheless, there are hedgerows, hedgerow trees and field trees within and around the appeal site.
There's a few.
Yeah.
Yeah. Those are not the ones that, when it's talking about the positive landscape attributes, those are not the ones that they're referring to. Again, in the wider area, there's a much stronger, where there's a strong network of hedgerows and hedgerow trees. And that's not what we have here. We have a weak network.
Well, Mazid, you weren't party to this assessment, were you?
No, but I'm looking at the wider character area and I can see
Yes.
that.
Well, forgive me, you said that the authors of this document did not have the hedgerows, hedgerow trees and field trees on this site in mind. You have no idea what they had in mind.
No, but I can see that the character of a strong network of hedgerows and hedgerow trees and field trees is much more evident in the area to the north than it is on our site. If you look at an aerial photograph, that is apparent.
Okay. The other bullets, they concern attributes that one will find on other parts of the landscape character area.
That's right, yeah.
Yeah, I mean, the character area itself is a mosaic of fields and different areas of land. Some will be wooded, some will be farmland, some will be pasture, some will be, as it says, seasonally wet soils fed by small brooks.
Mm-hmm.
It's a large character area containing a number of different parcels of land.
Yes.
Yeah. And one would not expect any appeal site, in reality, to contain more than one or two features identified in the character assessment.
No, I mean, there were some, as I say, there were parts of the character area that demonstrate those positive attributes much more intensely than others. And like my point is that the appeal site is not one of those areas. Because
the appeal site, I'm moving on now. The appeal site has an unusually rich network of footpaths, both crossing it and in its immediate vicinity. Doesn't it?
I mean, it has got clearly it has got footpaths crossing it. Whether that's unusually rich, I think I'm slightly disagree with Mr. Petra on that. The UK the landscape is covered with footpaths. So I don't think this is particularly outstanding in the provision of footpaths in this area. I mean, all around Farnham, there were footpaths that go out from the town into the wider countryside.
Yes. The LVA describes the footpaths as apparently well used, and that was Mr. Petro's evidence. Do you disagree with that?
We don't have any surveys of footpath number of people using the footpaths, so I can only there were some people on the footpaths when I was there, but we don't have any counted numbers, so it's a slightly speculative comment.
So far as detracting features are concerned, the appeal site itself doesn't have any detracting features of significance, does it?
Not particularly, no.
And the boundary between the appeal site and the Abbey View development and the university, it's not a hard edge because it's composed of trees and hedges and so on, but there is a clear division, isn't there, between the, if you like, urban Farnham to the south and the appeal site and countryside to the north.
Yeah, as there often is all around settlement edges. I was looking this morning at the site in Lower Hale. There's a reference to that CD 10.3, I think the appeal decision, which was allowed, and it was very much the same situation where the development goes beyond a confirmed tree line, and the inspector found that was acceptable.
Determined, I assume, on its own facts.
Yeah, absolutely. But I do refer to that in my evidence, so you pick that up. Thank you.
I'm going to move on then to visual receptors. And I'm sure we can agree in accordance with Glivia that the highest sensitivity visual receptors are people living in their homes and people on public footpaths enjoying the countryside for its attractiveness.
Yes.
And so in any assessment of the impact of development on visual receptors like those, you would give them the highest sensitivity.
Well, you would, as we spoke quite some length yesterday about that, it's both the susceptibility, those have the highest susceptibility to change, but then we need to look at the value of them as well. So there would be scenarios where it might not be the case. So when you're looking at sensitivity, you need to look at the value of the views as well as the susceptibility.
Those values, and indeed, I mean, I think this is common to pretty much every aspect of the assessment that you and Mr. Petro and anyone carries out of this sort. Susceptibility matter ultimately of judgment.
Yes. Yeah.
Value plainly a matter of judgment.
Yeah, I mean, we obviously use I look at it as a professional, I look at a lot of sites and I'm able to, I hope, give some sort of calibration of what I think is higher value and lower value and hence we give the narrative to explain how we get to that.
Yes,
conclusion.
but ultimately, yes, but it's your judgment. Another landscape architect may come up with a different judgment.
They may do, yes.
So susceptibility and value, which feeds into sensitivity. So sensitivity is itself ultimately a matter of judgment. And that's true also of magnitude of effect, matter of judgment.
Yes, but I mean, yes, but it's about giving transparency of how you reach that judgment.
Yes, absolutely. But two people can no doubt set out very fully their analysis and come to different judgments.
Yes.
Yes.
Yeah.
And at the end of this inquiry, the question is not whether your judgment is a good one or whether Mr. Petro's judgment is a good one. It's what judgment the inspector arrived at.
The inspector must come to that judgment herself, yes.
Yes, absolutely.
But I guess what she needs to look at is the evidence and the reasoning for how each of us come to that judgment and use that to hopefully assist her in coming to that judgment.
But ultimately, the judgment is that of the inspector, having gone to the site, having looked at the plans and so on. No doubt she'll draw what she finds valuable from the evidence.
Yes.
Yes. Effects on private views from residences.
Mm-hmm.
Do you say that is irrelevant, that that's something the inspector should not take into account?
I think, well, we went to the clarifications note. It's generally, there is no right to review, so it's not a planning consideration, as it can't be, because if we took into consideration every private view in every planning decision, then I think it would be very difficult to allow anything. But so it's not, in my view, it's not. More important is the views that are experienced from public places, public roads through the residential areas. Yeah.
I do want just a clear answer. Are you saying that the inspector should simply ignore as being an immaterial consideration views from private properties?
Yes.
Thank you very much indeed.
Thank you.
Thank you, Mr. Green. Okay, sorry, Mr. Lisson, when you're ready.
Yes, just two matters. Miss E, can you take up your proof of evidence, please? And this is in the context of the questions you were being asked about the statement of common ground, and the characteristics that you were taken to at 3.14 of the statement of common ground. Do you, at 210 in your proof of evidence, set out an analysis of your view against those characteristics?
I believe I do. Yes, I think I go through, yes, I go through each one of them and I explain how I think, to what extent they're present on the site.
Sorry, I missed the
Paragraph 2.10.
2.10, 2.10, it's page 8 of Miss Eads' proof of evidence.
Miss Powell, you're waving at me. Is there something wrong?
No, they'd be entitled if
I was
they're
going, well,
objectors.
yeah, I was going to, well, I was going to come to that point as well. I was going to allow re-examination first, and then if there are any mock-up questions, then I'll take those. Okay?
Yes, so I think the answer was yes, at 2.10, you undertake an analysis of the points that were put to you in cross-examination.
That's correct.
Yeah. Okay. Did Mr. Petro do that?
I don't believe so. Certainly not in his, not in his evidence, no.
And secondly, the last question's about all these matters being matters of judgment.
Mm.
When you are assessing the value of receptors, is there any guidance that is produced by the Landscape Institute or any other body in terms of how you arrive or criteria against which you assess value?
Yeah, so judgments on value, well, in terms, yeah, judgments on Livia gives us a guideline approach to how to approach the value and sensitivity of receptors, and that's what I use in my assessment as a framework for my decision making. There's also an additional technical guidance note, which is a core document or not.
Depends what document you're talking about.
Hang on. So it's referred to in the LVIA. It's the technical guidance note 0221, assessing landscape value outside national designations, published by the Landscape Institute. I'm not sure if that's a core document or not.
I don't think it is a core document. Where is it referenced?
I reference it in paragraph 4.15 of the LVIA.
Hang on, 4.15.
And it may be in my proof as well. It was published in 2020.
Hang on, just slow down, please.
Sorry.
Let's just find this. So 4.15 of the LVIA or the LVA.
Yeah.
Which version of the LVA?
That's.
Because I'm looking at the March 2024, paragraph 4.15, and that starts the study identified the landscape value. So can we make sure we're...
I'm looking at CD 2.15.
Yeah.
Paragraph 4.15.
Part 1. It's not what mine says.
CD 2.15.
Oh, that's what this document claims to be. Yes.
March 2024, LVIA.
Madam, do you have that?
No, my team isn't showing that at the moment. I'm going in and reopening it in case of the
What section of the LVA is it in?
Sorry.
Let's see if we can find the paragraph numbering. It's change of some sort. Is it in the baseline appraisal?
It is in, talking about landscape receptors, that's in section 4. There's 2 4.5. There's an error in the paragraph numbering. It's obviously jumped. So it's on PDF page. Yes.
This... No.
Which starts with there's a subtitle, landscape receptors.
And I've opened up 2.15 of the support document library on the council website. So
Yeah.
that's electronic. You've got the same, Mrs. Green.
Madam, I have, and as you say, there are two,
The apologies, the paragraph numbering jumped, so there's two 4.15s.
And does it begin an assessment of the
Yes,
existing
yes.
value of each receptor?
Yes, sorry,
Good.
apologies.
Sorry, we're all in the right place then. Good. And you were referring to some additional Landscape Institute guidance.
That's
O-
right.
To 02/21.
21, a footnote 5 gives the full reference of that. We can provide you with that, ma'am. And that sets out a structured approach to the attributes that should be taken into consideration when you're thinking about the
Okay.
value of landscape.
And I appreciate you don't have that document in front of you.
I know it fairly, I was part of the working party that I do know it quite well.
You don't know it quite well. Okay, well, it can be provided, so that's not an issue. But can you just give me some idea of the kind of factors that you need to take into account when you are arriving at your judgment
Sure.
as to whether or not the receptor, whether that's a landscape or a visual receptor, is a valuable one, and indeed at what sort of level you pitch the value?
So the kind of key considerations that one would, certainly when looking at landscape receptors, are components like its cultural heritage, its natural heritage, its condition, any particular associations that it has with cultural or historical events, its distinctiveness, its recreational value, perceptual and scenic values, and sort of wildness and tranquility and functional. I do summarise those in paragraph 4.15.
Yeah, yes.
And it's those that led me to come to the conclusion that the site should not be considered as a valued landscape. And I think that is actually an agreed matter with myself and the council. It's in the statement of common ground.
All right, thank you very much. Thank you. Those are all the questions I had.
Thank you, Mr. Lisson. I'm just going to check my questions. Yes, just a couple of questions received from me. So you talk in your proof fairly early on at 2.25. You don't necessarily need to go there because you know it. But you talk about views on particular pockets or sites within landscape character area. And this is kind of been questioning a bit anyway, but just for my own sanity. It's possible for a site to contain several positive characteristics, and Mr. Green took you through those from the statement of common ground, or one or more of those characteristics, isn't it, generally?
Yes.
Yes. Is it essential for them to have several, or may they just have one or two, but they be of particularly high quality?
So where this has come from is that in the landscape character assessment for LCA 6, what it does is it identifies the positive attributes of that character area.
As a
you know, this is what it is, and these are the particular elements that are valued within that character area that of which they call the key positive attributes. So obviously there's lots of, there are lots of elements and components to it, but what the assessment tries to do is pull out the things that they think are most essential to that character area. And my case is that I don't think the site, demonstrates those to any extent that those positive attributes would be eroded by the development.
And so you may have answered this slightly, but just to, Mr. Green talked about, used the phrase a mosaic.
Mhm.
So a mosaic of characteristics and sites that make up the character area. And whilst it may not sort of be exemplary in your view of those characteristics, does that nevertheless take away from its importance to contributing to the landscape area as a whole?
So I would say the areas that contribute most to the character area are the ones that demonstrate those positive attributes most strongly. So in the wider character area, we have extensive areas of quiet rural farmland with large woodland blocks and a really intact, strong network of hedgerows. And those are the more sensitive, more valuable parts of the character area because they demonstrate those attributes most strongly.
Thank you. And again, in your proof, and I think this is paragraph 4.23, and you don't have to go there, but it was just
Sorry, ma'am, can I just add one other point onto that last question?
Yeah.
It's just the observation that most of that character area, LCA 6, is an area of great landscape value. So it's an area that's recognised higher value and has got that local landscape designation on it.
Thank you. And actually that leads into should really be my final question. And you talk about the change, so paragraph 4.23, we may as well go there if you wouldn't mind in your proof. It's just, it's again, it's the effect on the character of the site. And you talk about the last sentence. As a result, instead of forming part of a wider area of landscape to the north of Farnham, which has a semi-rural character, it would share a similar character to that of the developed areas of Farnham to the south. Do you think that this change would be harmful to the existing contribution that it makes, even if it's in a subtle way, in your opinion, but to the existing contribution that it makes? Do you think that change in association from rural to the more urban scale would be harmful?
To the site or the wider area, or to
both. I suppose actually, yeah. If you
Yeah.
could just do to the site
So-
and then to the wider area.
so I think it's kind of an agreed matter that I think that the wider character area is not, the impact on that is minimal, if at all, because it's a small area adjacent to the existing settlement edge. So that core heartland of the higher valued landscape is preserved intact, is not harmed at all. Clearly there is a change to the site itself because you're changing it, you're introducing development to part of it.
Thank you. Nope, that one's done. Okay, thank you. So I am going to invite questions of interested parties. Now, yesterday I allowed Mr. Free to ask a question of the council's witness, and Mr. Litton was entirely right to remind me that that's not the done thing, because it's procedurally unfair. So, Mr. Litton, I apologise for that. I can only say I got carried away in the spirit of questioning. So I will invite interested parties to ask questions of the appellant's landscape witness. If you're happy to do so, or would you like a short break before we do that?
Happy to go on.
You're happy to carry on. Okay, so if anyone has a question, can they make themselves known? Councillor Powell? Are you happy to stay seated there, Ms. Eade, or would you like to move?
No, that's
around?
fine. I'm going to have to look at you when I answer, so because of the speaker, but. Thank
Thank you, ma'am. Thank you. Can you, I guess one of the issues that the community's been struggling with, you've answered in terms of what you're saying is the 2024 documents are wrong in terms of the visual impacts and they represent the 2022 design. Can you just confirm that?
Yes, so it's just the visualizations. Sorry, I'm going to have to look at it's just the visualizations that are incorrect in the LVIA. The correct version is the ones that we've been looking at, which is the CD 1.40. But the conclusions of the LVIA were based on the correct visualizations.
Okay, can you just go to, so the document that you're telling us has got the right images in it is, oh dear, 140?
That's right.
CD 140, could you just turn to that for me? And go, it's electronic page 7. I don't have any idea what page numbering it would be in the paper world, sorry.
Yes, I've got that, thank you.
So if you look at page 7, can you see the university buildings in that image?
Yeah, you can see the roof line of it above the trees. So it's just, if you look at the church tower and then it's immediately below that, so the sort of light grey.
So it's immediately below the church tower. So those levels were selected to ensure there was no impact on the church tower, would you say?
Quite possibly, yes.
Okay, so there is an ongoing need for university accommodation. In fact, they've just opened a block in Aldershot because they were limited on how high these buildings could be. But you can see that line, you agree the line of the university buildings is below the church tower currently?
Yes.
Thank you. And if you just go to CD 210 for me.
Sorry, what is that document?
It's an illustrative, I believe, based on what you've said earlier, that's the current illustrative plan, the final one? CD 210?
13.2 is actually got the most recent one.
Okay, let me
It's
pull that one
only,
up.
there's not major, the changes are really to do with the street tree planting. So I've got.
Let me just make sure that it says the same thing. Please just give me a second.
But if you give me the CD reference again, I can call that up again.
That's right. I can go to that. So you're saying it's 13. Sorry, what was the number?
13.2.
What page is that map on in that document?
5.
No, it's actually not the same. So can you go to CD 210? And can you zoom into the area around between buildings 55-8 and 5962?
Sorry, which numbers?
Between 55 to 58 and 59 to 62. There's some white text. Starts with units lower pitch.
That's yes, yep.
So can you just read what that says for me?
Units with lower pitches, stroke articulated roofscape to minimise impact on view to St Andrew's Church. And that's built into the parameter plan. Actually, there's a zone in the development parameters to keep the building heights lower in that area to keep a view through to the church tower.
And where's that captured, given that this is an outline application with access only? So how is that protected? How's
It's
that
ca-
view
it-
protected?
It's captured on the parameter plan, which is CD.
So I guess I'm asking how it would protect that view from outline
Yeah,
to detailed.
It's protected on the parameter plan, and let me just get that up for you. It'll be a CD2 drawing. I think it's 2.7. Yeah, it's CD 2.7.
Is that document referenced in a condition, or where's that
I think that's one of
captured?
the it's one of the plans to be approved.
So it is in a
That's-
condition.
That's the purpose of a parameter plan.
Okay. And so if you look at the drawings associated with the visualization that you believe is correct, which I think was 140, CD 140, you can clearly see that the university roof line is below the tower, and that's the corridor that's going to be protected by that paramix plan, is it? That visual.
Yes.
And so the error in, or the designer has developed from 2022 to 2024 to incorporate protecting that narrow view.
That's correct. Yes, that was something that came through the discussions with the council, and we recognised that was important. So that was built into the parameters to preserve that view of the church.
And obviously the inspector will visit the site and will look at the views from other angles and see if there are other angles that she will make a judgment as to whether they need to be protected or not. Thank you, ma'am.
Sorry, Ms. Powell, was that a question or a statement? Because you should only be asking questions.
Oh,
of
I'm
the
so sorry.
witness.
I often fail. Apologies. Thank you.
Was there anything else you wanted to add, Mr. Lytton? No. Okay, super. In that case, Ms. Eade, thank you very much. That's your evidence done, and in good time. So thank you, everybody. So we'll move on to the council's witness, Mr. Sampson. We'll have a short break now, and then we can hopefully have a clear run through to lunch. So the time is 10:32. I suggest we reconvene at 1:45, if everybody's happy with that. So we're adjourned until 10:45. Thank you. Oh, sorry, we need to, if we're going to have a conversation, we need to have one all together, so. Mr. Listen, Mr. Green, could you just join me for a second? Sorry. Yes, you can make a statement, it's probably best to do it before starting work. Yeah. Come back. So we'll take a break and then. Thank you.
Yes, good.
Got that tab here, so I can get that without the.
What's the CD number?
Well, just on my sort of paper, I've got the whole tab. CD 2, and 14, 17, 20. The plan, but I, yeah, so I've got to find which. Oh, hang on a second, I think it's 17. It's labeled, yeah.
Okay. Yep.
Yeah.
Good, and you've got.
Yes, You actually got the Northwest.
Yeah, I wasn't quite sure. There were three, we're not saying all the pets. No, I think it's
Right. It's 10:46, so if we could reconvene, please. Everyone take their seats and make sure phones are switched off to silent. I've had a flurry of emails come in, which is exciting. One of them in relation to the documents from Councillor Powell was sent to Mr. Green's chambers and the case officer, but I can't see that it was in fact sent to the appellant. So is it possible for the council to forward that, or is it possible for the council to forward that to Mr. Litton?
Yes, I'll do that now.
Mrs. Powell?
And we're making copies.
Sorry, Mr. Green asked me if I would reword that overnight, which I've done in a cleaner email with less information on it, which has gone to Catherine and to Mr. Green and to Mr. Kerr this morning. It's just a much more concise version of the document because that's what Mr. Green recommended I did.
Okay, thank you. I've been forwarded an email that was submitted to PINS last night. I've not actually read it yet because I was mindful that that Mr. Litton's chambers weren't included. Could I leave that with you, Mr. Green, before I accept anything to?
Yes, absolutely. I mean, these were documents requested by Mr. Litton. They're now provided. I've just forwarded them to Mr. Litton. Obviously, he will want to read
Super.
them before.
Yes,
Um,
before I do.
before you do, madam. Yeah.
Okay, super, thank you. So I will park that for a moment and we'll return to it later on. Other than that, I've received the updated Farnham Neighbourhood Plan housing table, so thank you for that. And I received the notes and clarification on Glivia core document 6.6, which came in from the appellant, and the Farnham core documents list, which also came in from the appellant. I'm not entirely sure. An updated core.
Right, so it's an updated list to include that.
Right.
6.6.
Okay, thank you. And well, yes, that's the thing, isn't it? I don't mind. Happy to take it either. Well, I guess inquiry document really. I think, yeah. Otherwise, we're changing the core document list. So I'm ignoring the Farnham core document list update then. Is that correct? Yes, and I'm taking that core document 6.6 as an inquiry document.
I'm not sure how it's being done by Waverley, but I'm not sure that the core document list should keep changing. There
No.
should be a separate folder which says inquiry documents, and they should then be uploaded as inquiry documents, so that the distinction is made between the core documents and the inquiry documents.
I had assumed that was what was happening.
I will check.
Thank you, Mr. Green. Okay, during the break, were we able to circulate the representations of people that came in from the interested parties?
Haven't been provided with them.
We're
They're being
printing them at the
printed now.
moment, that's fine, so that can be dealt with today, splendid. Okay, I don't have anything else coming in. Was there anything that anybody else needed to update me of in terms of housekeeping? Mr. Green, no, Mr. Right. So just as we broke just after the adjournment, and the ward councillor approached and asked if they could make a representation, which of course they're very welcome to do so. So if you could come up to the microphone just behind Mr. Sampson, I think it is, isn't it? Thank you. I don't know if you were here yesterday to hear me repeat over and over again, but you were, so I don't need to clarify.
No.
Splendid, thank you. So
Right.
when you're, once you've made those statements, when you're ready.
Well, my name is David Beeman. I'm the ward councillor for Farnham North on both Farnham Town Council and, in fact, Waverley Borough Council. If you want my qualifications, I've got first class honours degree in geography and an MSc in transport studies, but that was many years ago. And really, I want to make and I'm open to questions if necessary. Right, okay. I'm the one member and I've been a member for Farnham Town Council since 2011 and for Waverley Borough Council since 2018. I was a member of the planning committee that made the decision to sort of refuse this application. And in fact, prior to that, I was in fact chair of the planning committee. Over the last day or so, I've heard lots of technical arguments over this particular application. And I want to just make a plain statement. Well, there's two parts to it, really. The first is that the Farnham Neighbourhood Plan, which references have been made, in fact, is a living, live document. It is still valid, and this particular area of the town was not allocated for residential development. I believe, and for reasons that were quite clear at the time, and I believe that that should still be the case, and that as an inspector you should take account of that, because if you that, as Councillor Coburn pointed out in her earlier submission, that this is a lot of blood, sweat and tears went in this particular document. And that, in fact, you know, it withstood, it had a public referendum, 95% yes vote. And in fact, it had sort of it went through legal inquiries as well. So I believe that as an inspector, you know, if you were sort of were to sort of allow this appeal, you're in fact going against the Farnham Neighbourhood Plan. But that apart, I would say this particular application it's a living document, but therefore it's subject to change and it's subject to review now. This particular application does have some merits to it. I mean, we have orchards, we have all sorts of nice things attached to the application, don't we? But I would like to bring in inspectors to the main point of the application. It's an outline application except for access. And it's the access which concerns me as a member. Certainly when we were discussing this at the planning committee, access was an issue. Now, I know there's been representations, claims that Surrey County Council says the access is acceptable. I think you make your own judgment when you make your site visit to this particular, but we believe this site access is not, in fact, practical. The application itself, fine. As this evolves and it's in review, again, fine, we may well find that the development of the site may be the next stage in development, but not through Keepsake, Close and Cascade Way. Thank you very much.
Thank you, Mr. Beeman. Did you have any questions, Mr. Liston?
Yes, I do. Sorry, Councillor Beeman, did I understand that you were a member of the planning committee that refused the application contrary to the officer's recommendation?
Correct.
You were the chairman of that committee?
No. No. Just a member.
Just a member, okay. And I think what you've just said to me, but I want to make sure I've got a correct record of this, is that the development of the appeal site itself for housing was not really an issue for the committee. Your real concern was the access using Keepsake Close. Is that right?
That is my view, yes.
In your view or the committee's view?
I would say the committee was held that as a major point, yes.
Sorry, I didn't quite catch that.
Yes, the committee was view as well.
So the committee's view is, in principle, development of the site, okay, but access a problem.
Well, I would say that certainly initially it's contrary to the neighbourhood plan anyway.
Yeah, I understand that.
As we evolve the neighbourhood plan, it may well be that the development on this site could well be acceptable.
Okay, all right. Thank you very much.
Thank you, Mr. Beeman. Okay, let's move on then to resuming the evidence. So we're going to move on to the planning topic and commence with the council's witness, Mr. Sampson. Mr. Green, please proceed when you're ready. Thank you.
Thank you very much, Madam. I'm going to introduce Mr. Sampson first, and as I say, or as I said yesterday, because there are third parties here, I'm going to ask him to read some, but not all of his summary. Mr. Sampson, you're Christopher Sampson. You have over 25 years professional planning experience in public and private roles, including in several local authorities. You're a chartered town planner. You have a Bachelor of Arts honours degree in urban planning and management and a postgraduate diploma in town and country planning. Is that correct?
That's correct.
Just on your experience, have you had any experience in the development industry?
Yes, I have. Yes, as well as the local authority and consultancy experience. I spent 5 years as a planning manager for a regional house builder, covering sites across Sussex, Surrey and Kent.
Thank you. You've produced a proof of evidence and a summary. And I think for those who haven't had the benefit of reading your proof of evidence in full, I'm going to ask you to read some paragraphs from your summary. Can you read first paragraphs 4.4 to 4.8?
In relation to the first reason for refusal, it is considered there are two main issues arising. Number one, the conflict with the neighbourhood plan built-up area boundary and provisions of policy FNP 10, and two, the effect of the proposed development on the landscape character and appearance of the site and surrounding area and visual impact. Local Plan Part 2 makes clear at paragraph 3.5 and 3.12 that settlement boundaries for Farnham are specified by the Farnham Neighbourhood Plan. Apart from the access route, the site lies outside the built-up area boundary for Farnham and in the countryside. The appeal site is not one of the 12 sites allocated for residential development in the FNP. Neighbourhood Plan Policy FNP 10 states that outside the BUAB, priority will be given to protecting the countryside from inappropriate development. It is considered that the criteria of FNP 10 all need to be complied with in order to justify development in the countryside. In this case, the proposals do not comply with criteria A and E. The appeal proposal is therefore contrary to policy FNP 10 of the Neighbourhood Plan. This is supported by policy RE1 of the Local Plan Part 1, which states that in areas of countryside beyond the green belt, the intrinsic character and beauty of the countryside will be recognised and safeguarded in accordance with the NPPF. The proposed development would have adverse landscape and visual impacts on the appeal site, which would be perceived from a number of public locations. The appeal site is an area of pleasant open countryside that assists in defining the character of Farnham and its setting, and is designated as an ASVI for this reason.
Thank you. That's the first reason for refusal. Can you go to paragraph 4.14, please, and read from 4.14 to 4.21?
Reason for refusal 2 relates to the effects of the access works on residential amenity, visual amenity and character. Paragraph 131 of the NPPF states that the creation of high quality, beautiful and sustainable buildings and places is fundamental to what the planning and development process should achieve. Good design is a key aspect of sustainable development. The planned layout and design of the access route as part of the overall Abbeyview development incorporates a landscaped verge running through the layout, which provides relief from the built form and hard surfaced materials. The continuity of the verge helps to provide a sense of place and is perhaps a modern nod to the traditional Surrey suburban boulevard. The proposed access route has a length of approximately 230 linear metres along the existing highways, plus the additional length to be created to reach the currently agricultural part of the appeal site. The widening of the existing road by 0.7 metres from 4.8 metres to 5.5 metres along the length will widen the carriageway by 15% and for much of the length will reduce the established verges from 3 metres to 2.3 metres, equating to a reduction of 23%. These changes will lead to a more engineered feel and cramped arrangement with highway infrastructure closer to buildings. The creation of a 5.5 metre wide highway with separate footpath through the shared surfaced and landscaped areas at the northern end of Keepsake Close will also undermine the hierarchy of streets and spaces within the originally planned layout and thereby undermine its attractiveness and legibility. The northern end of Keepsake Close will become a through route rather than a cul-de-sac serving a small number of dwellings. The transport report submitted with the planning application by Motion Transport Consultants states in table 5.1 of the document and at paragraph 5.3 that the proposals are likely to generate around 45 to 50 vehicle movements in the morning and evening peak hours and around 400 vehicle trips daily. Given that the properties at the northern end of Keepsake Close will currently experience no through traffic, I consider this to be a notable change in traffic movement and associated effects. It is considered this will have some detrimental effect on the quality of life of the existing residents owing to disturbance, for example from traffic noise, car headlights and so on, coupled with the overall erosion of the environment owing to the extended highway infrastructure. In summary, the proposals as a byproduct of achieving satisfactory access to the currently agricultural part of the site will have a material adverse impact on the established and planned character of the existing residential area and the established residential amenities of some residents, contrary to the policies stated in reason for refusal 2.
Thank you. Finally, paragraphs 4.32 to 4.34.
The effective operation of the plan-led system relies on a degree of certainty and consistency in decision-making. I consider that if the proposals were to proceed, it would undermine the effective operation of the built-up area boundary and neighbourhood plan policy FNP 10, which in turn would have adverse consequences for the protection of the countryside around Farnham. Additionally, allowing the proposals to proceed would undermine public confidence in the planning system, given the clear provisions of the Farnham Neighbourhood Plan. Paragraph 14 of the NPPF states that in situations where the presumption at 11D applies to applications involving the provision of housing, the adverse impact of allowing development that conflicts with the neighbourhood plan is likely to significantly and demonstrably outweigh the benefits. Accordingly, and taking account of this, notwithstanding the acknowledged extent of shortfall in housing land supply on a borough-wide basis, it is considered that the harm associated with 1, the conflict with the neighbourhood plan spatial strategy, and 2, the adverse impacts on landscape, local character, appearance and amenity would significantly and demonstrably outweigh the benefits. For all of the above reasons, I consider the appeal proposals should be dismissed.
Thank you very much. There have been some additional documents produced in the last day or so, one of which, as I understand it, replaces the first of your appendices. Your Appendix 1A has the status of neighbourhood plan allocated sites in Farnham. And as I understand it, a document was handed up a few minutes ago, given ID reference 11. And that's an updated allocated site delivery table dealing with allocations in Farnham and in particular in the neighbourhood plan. Can you just explain first of all what that table is and what it's meant to demonstrate?
Yes, certainly. So the table is meant to demonstrate the current position regarding delivery on allocated sites in Farnham, both within the LPP1 and the FNP. There's a degree of overlap. Some sites are in both. So that's in essence what the table is about.
Thank you. And does this table include windfall development or not?
The table does not. I refer in my main proof to the total number of windfalls that have been delivered in Farnham in the last 5 years, which is 314 units.
Thank you. Now, the table goes through the different allocations in the neighbourhood plan policy 14A onwards. There's one area of disagreement relating to allocation FNP 14I, and that's concerning the University for the Creative Arts at Faulkner Road. Can you explain what the dispute is between the parties on that site?
Yes, it's really a question of methodology of converting student rooms or units into a C3 equivalent for the purposes of monitoring. So the Borough Council uses the methodology in the Housing Delivery Test Measurement Rulebook, which means that the total number of units after you've taken account of any net losses during development is divided by 2.4 to actually reach a figure of 90 in this case. I would just mention the original version of the table, I think referred to 105, but because of the net losses during development, that has reduced to 90. So there's a slight adjustment in terms of my evidence there accordingly. The appellant's methodology is basically to divide by 3, as well, I think the neighbourhood plan policy does refer to that. However, the Borough Council are required to use the HDT method in their reporting.
Thank you very much. The other document that was handed up was the weight table. And do you have that to hand?
I do, yeah.
We're going to just go through one or two of the entries in that. The first entries concern the contribution that the appeal scheme would make towards local housing need through the provision of market and affordable housing. And one can see that the weightings given by the appellant and the council differ. As far as you are aware, is the appellant a house builder or not?
As far as I'm aware, they are a land promoter rather than a house builder.
The application we know is an application for outline planning permission. If the appeal is successful and outline planning permission is granted for up to 83 dwellings, so therefore major development, would that permission of itself add to the council's housing land supply?
I think having regard to the PPG on housing supply, then it would be doubtful at best because of the uncertainty that would exist around delivery and timescales for an outline proposal, particularly where all matters are reserved except access. A number of factors that would also feed into that, noting there's no obligation within any of the draft without prejudice planning documents, the section 106, to a phasing schedule or delivery schedule. There would be a need to market the site to a developer, which according to the applicant's website is usually through a tendering process, so that would inevitably take some time to achieve. There's also no, as far as I'm aware, no affordable housing provider identified at the present time. So that would take time. Obviously, there would be the reserve matters process to go through, as well as conditions discharge. And I am mindful that in this case, the highway works, as we've heard, are extensive to obtain entry to the site, which I feel would be quite complex given they would be coming through an established residential area, as I said, of about 230 metres in length to actually achieve access to the site. So given all of that, I think, and the delivery uncertainty, then I think it would be the case that wouldn't add to the 5-year supply position.
Thank you. You refer to the planning practice guidance. Madam, just for your note, that's the planning practice guidance on housing supply and delivery paragraph 7. Thank you. Now, reason for refusal 2, it concerns the impact of the proposals on the Abbey View development. Could you turn up the proposed access arrangements plan, which I believe is CD 2.17?
Yep, got that.
And it may just be helpful if you could explain by reference to the plan what the areas of concern are.
Yes, certainly. So, as I've made clear in the evidence, and as you can see on the plan, there's a widening. It's perhaps not so clear on this plan, but there's a widening of, as a matter of fact, 700 millimeters of the carriageway from 4.8 meters to 5.5. We have accepted that the trees can be replanted. Obviously, that will take some time for them to mature, but that's a point that we're not taking in relation to street trees. But in relation to the established character and the designed and planned layout of the estate, it will, in my view, rebalance the position from what was designed as a key route through the Abbey View development, making it more engineered and changing the balance of hard surface and highway features and planned landscaping. So that will erode the character. I think in Mr. Packer's proof, it refers to 36% loss of the landscape verge within Keepsake Close, which again I do feel is a significant figure. So that's in terms of the verge. The further concern is the punching through of the access through what is currently a shared surface driveway serving half a dozen properties or so, and coming through the landscaped edge of the existing development, with a fully engineered highway with separate dedicated footpath, quite contrary to the current character in that part of the site, and moving through across that soft edge and into the appeal site. Additionally, the footways and so forth, because of the widening, will be closer to the houses in certain places, and you can see there, particularly on the right-hand side of Keepsake Close, there's very close proximity, particularly to those properties. So those would be the key concerns that I would have.
Thank you. Now, you've referred, I think, to the effect of lighting and so on properties, just for the inspector's note, which in particular properties are they?
Yes, so in terms of the lighting effects, I think the primary concern would be the two properties at the northern end of Keepsake Close, which are number 18 and number 5, either side of the access route proceeding northwards.
Thank you.
In terms of noise,
yes,
obviously that's somewhat different.
Yeah.
So I think there would be a broader impact. I think there would be some notable impact to all residents actually within the established development. I think the impacts would be greater towards the northern end of the established layout, because obviously you haven't then got the alternative offshoots off of the main route through the development. So you know, accordingly, the established baseline conditions from a noise point of view will be lower towards that northern part of the development.
We have in Mr. Packer's evidence, we have a a noise impact assessment. I think it's Appendix 7, and it begins on electronic page 203.
Yeah.
So Mr. Packer's evidence, CD 9.1. Have there been any earlier noise impact assessments submitted as part of the application?
No.
Again, see if I can get the right electronic page number. Section 6, which is, I think, page 218. There is a table setting out essentially the baseline traffic as it is now at the points of measurement, and then the baseline in 2028 with the development proposed in place. And it's split into east and west. Do you understand that division?
It's not very clearly set out, I don't feel, but I've made an assumption on interpreting it that sort of west would be in effect leaving the Abbey View development, and east would be entering or coming through the other way. Just looking at the figures there on the peak hour, where in the morning you would expect a net migration out of the site. So the westward figure is 29 and the east is 10, and the reverse is true in the evening figure. So whether that ought to be north-south in terms of, or east-west, but that's how I've taken it to or interpreted it.
Okay. Now, the assessment indicates that there would be an increase in noise levels as a result of the proposed development at 6.6. We can see it says, when applied to the current two-way traffic levels, the LAEQ 60-hour noise level at the end of Keepsake Close was calculated to be 35.4 decibels. Under future post-development conditions, the equivalent noise level was calculated to be 47.6 decibels, a difference of plus 12.2 decibels. When assessed in accordance with DMRB long-term significance criteria, an increase in that noise level would be considered to be of major significance. And then it explains, however, as Keepsake Close is currently a cul-de-sac with low traffic flow, any increase in traffic would have a relatively large increase in noise level. To determine the overall impact on the residents of Keepsake Close, the difference in noise level must be considered in the context of the absolute noise levels as stated in section 7.54 of the IEMA guidelines. What's your view of that?
I think it's quite striking in terms of the, to me, one of the key points here is the change to the established living conditions experienced by the residents. So, you know, the difference of 12.2 decibels from the baseline to the future post-development conditions would seem to me to be quite significant, particularly considering that unlike proposed houses with existing properties, it's not possible to condition mitigation for those third-party owned properties. You know, it's not possible to actually enforce or to seek to do that. And in any event, I think that would be, you know, not in accordance with good design principles to be seeking to retrofit such a solution to what would, you know, to given the overarching concern that I have. So yes, I think given the current ambient levels are where they are, taking account of the fact that at the northern end of Keepsake Close, you've got, I think it's 7 properties served off the driveway at the northern end. So to all intents and purposes, they're at the most only going to have about 4 or 5 houses worth of traffic passing a day. For some, it will be even less than that in comparison with the figure given in the noise report of 511 vehicle movements per day. I think there's some reference, or the noise report sort of seeks to perhaps place the impact within a broader context of sort of the wider national guidelines. I think that would take into account broader context in terms of towns and cities that would have a noisier sort of environment compared to the current situation here, which is very much quite a tranquil location at the present time. So I'm not sure it's appropriate to necessarily, just because it doesn't reach a threshold within a wider target, to disregard the material change in living conditions that would be experienced, in my view. And indeed, is acknowledged in the report. And it's perhaps the fact that there is, it even says in paragraph 6.6 that because it's such a low traffic flow at the minute, that any increase in traffic would have a relatively large increase in noise levels. So it's sort of there in plain text.
Thank you. I was going to move on then to the last issue I was going to ask you about in chief, and that's paragraph 14 of the NPPF. And is that something you could dig up, please?
Just bear with me. Sure.
Paragraph 14 begins, in situations where the presumption at paragraph 11D applies to applications. So we're talking about situations where the presumption applies. So what's the context in which this paragraph applies in terms of housing supply and delivery?
Sure. So it would apply in situations where there is a made neighbourhood plan that's less than 5 years old, but where there's a borough or district-wide shortfall in housing supply.
Thank you. We are in agreement that the neighbourhood plan became part of the development plan 5 years or less before the date on which, the date on which this inquiry is being held. And I think it's 14B that's in issue between the parties, whether the neighbourhood plan contains policies and allocations to meet its identified housing requirement. See paragraph 69 to 70. Can we just go to paragraph 69, see what that says?
Sure.
Again, for the benefit of those who don't have the NPPF in front of them, it begins, strategic policy making authorities should establish a housing requirement figure for their whole area, which shows the extent to which their identified housing need, and any needs that cannot be met within neighbouring areas can be met over the planned period. And then skipping a sentence, it says, within this overall requirement, strategic policies should also set out a housing requirement for designated neighbourhood areas, which reflects the overall strategy for the pattern and scale of development and any relevant allocations. Once the strategic policies have been adopted, these figures should not need retesting at the neighbourhood plan examination, unless there's been a significant change in circumstances that affects the requirement. First of all, at the examination into the neighbourhood plan, the Farnham neighbourhood plan, was there an identified need for the Farnham neighbourhood area?
Yes, there was, yes. And the examiner's report acknowledges that and indeed refers to a figure above that level within it.
Okay, so returning to paragraph 14, paragraph 14B, that is. First question, is there an identified housing requirement in the neighbourhood plan?
Sorry, just flipping back to 14B again.
Of course.
Apologies. Yes, there is, yeah.
Does the neighbourhood plan contain policies and allocations to meet that identified requirement?
Yes, it does. It has 12 allocated sites under the FNP 10 and 12, I think it is the was it 14? Sorry, it's in there's 12 sites anyway within the neighbourhood plan. Yeah.
Mr. Sampson, that's all I have to ask. There may be some questions for you.
Sure.
Thank you, Mr. Green.
Thank you, Mr. Sampson. Can I just identify the documents?
Yes, that would be helpful.
I do this. CD 4.2, 4.4, which are the committee plus the update. So CD 4.2 to CD 4.4. Then CD, do you want me to give you a list and then, yeah. Exactly. CD 4.2 to 4.4, CD 5.1, which is LPP1, and the maps that go with that, which are at CD 5.2. Then LPP2, which is CD 5.3, and the neighborhood plan, which is CD 5.5. I think that will be sufficient. I should just say then, in addition, the FNP allocated sites agreed note, which is inquiry document 11, and also the document weight to be given to the benefits, disbenefits. Did that get an inquiry document number? Did. Was that 9 or 10 or something?
So I've got weight given to benefits, disbenefits. Is that the one?
Yes.
Yes, I've got ID 7 for that.
7.
And then 11 for the delivery
Yeah,
table.
lovely, thank you. So those two documents as well, please. And in terms, so I'm going to start, please, just with the committee report, please, Mr. Sampson. Hands on. No, I've got it. Yes. Apologies. So I don't want to trawl through the officer's report, but as a matter of record, the case officer concluded that RE1, RE3 were in fact met. You disagree with that, as does Mr. Petro. The case officer also concluded that there would be no unacceptable impact on residential amenity. And that was dealt with in the officer's report under the heading of impact on residential amenity. You obviously disagree. Indeed, we heard from the ward councillor this morning, member of the planning committee, that actually the impact on residential amenity arising from the access proposals were actually really what the council was concerned about. Is that your understanding?
I can't really confirm that, or we've got the decision notice that has the reasons for refusal. So that's the case which is before us. I think I wasn't at the committee meeting. I think it would be speculation on my part to suggest anything other than the reasons for refusal are what is up for consideration.
No, but we heard the evidence from the member of that planning committee this morning, and he said in no uncertain terms that the concern was really two concerns. One is it was in conflict with the neighbourhood plan, recognised that, but he went on to say that he could see that this would be a future development, a future site for development of housing, and that in relation to this application, the concern really was about the impact of the access proposals through Keepsake Close. In fact, I think he went so far as to say, that this is an acceptable development, except for the fact that it has an access through Keepsake Close. So that we don't have to speculate, we take it from the horse's mouth.
I think that's one member of the planning committee. So with respect to the member, I'm not sure, he was recollecting or representing the entire view of the committee. I believe that was his own view, but and obviously it's some time ago since the committee meeting. So as I say, I think it would be speculation to go into that sort of territory. But obviously the access concern is reflected in any event in the second reason for refusal.
Yeah, and I mean, when we look at the update reports that were provided as part of this, first of all, there was a note provided in relation to the members' site visits. So that is, I think, that'll be 4.3, isn't it? Dated the 3rd of July. Indeed, we can see under that heading of, it's on page 3, internal page 3, members' site visit Friday the 5th of July 2024. I mean, that really is, at least the first point, all about the access, isn't it?
Yes, I'd agree with that.
Yeah. And then the second point over the page was about the landscape and visual impact of views on St Andrew's Church.
Yeah.
Particularly visibility about St Andrew's Church being grade 1 from footpath 94.
Yeah.
Yeah. And then I think there was a response, wasn't there, from Surrey County Council. We see that at CD 4.4, seeking to address the concerns expressed by members about the access. And again, I don't want to trawl through that. But it dealt with, first of all, the access strategy at 1, traffic generation at 2, and then went on to consider a whole raft of other highways-related concerns. And it concluded, didn't it, on internal page 6, under summary at 10. Overall, it's considered that the applicant's transport assessment provides a robust and realistic assessment of the impact of the proposed development on the local highway network, has addressed the transport requirements, etc., specifically with regard to ensuring safe and suitable access for all people, maximising sustainable transport opportunities, and demonstrating that significant impacts from the development on the local highway network can be cost-effectively mitigated to an acceptable degree.
Is that a question or it's just?
Well, that is the conclusion that they reached in relation to the very specific concerns that members had raised, including about the access. So at least from the county council's point of view, they are entirely satisfied that this has all been robustly looked at and is satisfactory. Correct?
Just quickly reread.
Yes, of course.
Just double check, but. Yes, in terms of highway network impacts,
Yeah,
I don't disagree.
including the access strategy.
Yes.
Yeah. And if you just jump back to the internal page 3, under that heading of access strategy, just look at, please, the 3rd paragraph, which talks about the indicative site layout, including a network of pedestrian cycle routes within the site. And then do you see 3 lines down, halfway through that line, it begins, however, at this stage, the CHA, County Highway Authority, is satisfied that the indicative site layout provides excellent permeability for walking and cycling between the site and the surrounding area, particularly to the range of services and amenities in Farnham Town Centre. Yeah.
Yes. Yeah.
And you don't disagree with that?
Whether I would consider them excellent, not sure. I'd say they're perfectly adequate.
Well, it's quite a difference between perfectly adequate and excellent, but the county council think that in terms of its permeability and connections, it's excellent. Are you disagreeing with that?
I wouldn't necessarily use the word excellent. I don't, I think there are good routes, and a choice of routes. I don't dispute that. I'm not sure I'd use the word excellent, but
Very good?
yeah, I'd say very good. Yeah. Yeah.
Okay. Thank you. All right. Now let's see if we just establish this. You agree, don't you, that Farnham is a sustainable settlement?
Yes.
You agree that the site is in a sustainable location relative to that sustainable settlement?
Yes.
Yeah. Okay, good. Can I ask you please then to turn up CD 5.1, which is the LPP 1. I just want to again just see whether you agree with the matters that are stated in that document. So first of all, internal page 19, paragraph 2.28. Appreciating that this was written in adopted in 2018, I think, wasn't it?
Yes. Yeah.
So
was it page 19?
Internal page 19 or paragraph 2.28. Sorry, internal page 18. I've got double double
page
printed.
18, yes.
Page 18, paragraph 2.28.
Yeah.
Waverley is in an area of high demand for housing. House prices in the area higher than the southeast average, almost twice the national average. Those figures might have changed slightly, but you agree in broad terms that is still the position.
I don't disagree with that.
No. Just take it down a few sentences. The SHMA shows the affordability of property in the housing market has worsened quite markedly over the past 15 years. The affordability pressures have been consistently more acute in Surrey than in the wider southeast. That's still the position, isn't it?
I haven't especially studied that data, but
You wouldn't disagree with it.
I wouldn't tend to disagree.
No. Can we turn over the pages to page 21, please, under the issues and challenges section? Second bullet point, housing. So this is paragraph 2.42 on page 21, second bullet point. Waverley is an attractive place to live, which is reflected in very high house prices. There is a pressing need for more market and affordable housing in the borough. That's still the position, obviously.
Yes, it is. Yeah.
Turning on, please. Page 65, in the context of affordable housing need in Waverley, paragraph 9.7. West Surrey SHMA calculates that if Waverley were to theoretically meet a figure of 314 new affordable dwellings a year, that is what the calculated or assessed need was, then overall 897 new homes a year would be required in Waverley, based on a theoretical policy requirement of 35% of new homes and all housing developments to be affordable. This would not be realistic, as it would result in delivery rates higher than anywhere across England over a sustained period over the last 15 years or over the pre-recession decade. The point that's being made there is that actually the adoption of a figure of 30% is deliberate, but under-delivers the amount of affordable housing as assessed through the West Surrey SHMA, doesn't it?
Can you just say, tell me which paragraph?
Yeah,
it was?
9.7 on page
Sorry,
65.
it just took a little while for my computer to catch up.
Yeah, sorry.
That's okay.
Tell me when you get there, because
Sure.
I
Yeah,
appreciate
it's easy
sometimes
that-
a bit of a lag.
Sure. Thank
So
you.
let me just, I read it out.
Yeah, I was
By all
listening,
means,
yeah.
read it again to yourself.
So para 9.7.
Yeah.
Yeah. Okay. Yeah.
The point I'm making is that that was a recognition in 2018 that were it to deliver the assessed affordable housing need, it would require 897 dwellings per annum to be delivered, whereas of course it doesn't do that. So 30% is not delivering the assessed affordable housing need. It's under delivering against a smaller target of total housing, market housing. Correct?
Yeah, wouldn't disagree with that.
And then we see the policy in AHN1, which sets that affordable housing provision at 30%, minimum 30%.
Yes. Yeah.
Okay. Now, in terms of policy RE1, we see that on pages 112 and 113.
Yeah.
Paragraph 13.6, areas of the borough beyond the metropolitan greenbelt will continue to be defined as countryside. Policy RE1 sets out the approach to such land in accordance with the NPPF. So it's a sort of blanket cover, isn't it? I mean, if you're not in the greenbelt, you are in policy terms countryside.
Yes.
Yeah. And we can see what the policy says in relation to that RE1. Again, difference between you and at least the council officer in terms of whether or not policy RE1 was met. And I understand that. Policy RE3, the text to which starts on page 122 under the heading landscape character. And it looks at a whole series of different designations, local designations, the Surrey Hills, AGLV, and AONB, the strategic gap. And then if you keep turning over the page, you get to 126, paragraph 13.44, areas of strategic visual importance. And we agree that other than being, in policy terms, countryside, the appeal site falls within that local designation.
Yes, that's correct.
Doesn't fall within any other national designation or local designation.
No.
And when we look at 13.44, we see, it tells us, doesn't it, what the purposes of identifying land as ASVI are.
Yes, it does, yeah.
So picking up the second sentence, the areas are designated because they are considered to play an important role in preventing, one, the coalescence of settlements, or two, because they are areas of open land that stretch into the urban area. So those are the two purposes of ASVI. Nothing to do with providing a soft edge to settlements, is there?
There's nothing about a soft edge of settlement.
No.
So I would agree
Two
with that.
purposes: prevent coalescence, or they stretch into the urban area.
Yes, I mean, I would argue there could be a role in terms of keeping the openness of the land, in terms of what is, in terms of what is considered to stretch into the urban area as such. I feel there is a role of ASVI. It's a bit subjective as to what stretches into the urban area, what doesn't. But yeah,
Well, we're going to come to that in a second. But I mean, your point that it plays a role in terms of preserving the countryside, that can't be right, because that's the purpose of RE1, isn't it? Because you're out in the country. If you're not in the green belt, you're in the countryside, and we can see that there are protected policies relating to the countryside. These are talking about very specific designations, national and local.
I would say there's RE1 is an overarching countryside policy. The ASVI is an additional designation.
Yeah. Can I ask you please to turn up the policy maps, which are at CD 4.4, I think, aren't they? Sorry, CD 5.2, CD 5.2. Now, there are two maps. There's one of the whole of the borough, and then there's an inset, which is the first of the two maps for Farnham. And if you look at the larger map to start with, i.e. of the, perhaps not the entire borough, but the western part of the borough, we can see that areas of strategic visual importance, ASVI, are those with a light green background and the heavier green stripes. It's going to take a while to load.
Sorry, it's just closed on me. So,
okay.
so you just
if you've got the hard copies, you might find that easier. So it'll be volume 1 of 2, and in against tab 5.
Yeah.
Sure. You might even go to that blue tab. There we go.
Yeah, thank you.
So 2 plans. First one, the inset, but I'm looking at the second one, if I may, please. So if we look at the legend, light green background, heavy green stripes is ASVI. And the policy reference is the RE3 policy reference.
Yeah, sure.
And I mean, it does exist a little bit, I think, down around Hazelmere at the very bottom. We're not worried about that. But we can see that there is quite a lot of this ASVI in and around Farnham. And if you turn to the inset map, that again doesn't give you a full picture of Farnham. You can see what area it covers from the inset itself. But again, the legend is the same. In other words, you've got the heavy green striping. It designates the ASVI.
Sure. Yes.
And just bearing in mind the purposes of, as set out in the text of RE3, purposes of ASVI. If I hold this up, it's probably easier. This part of the ASVI, and indeed this part of the ASVI, you can see that there is development either side. These are fingers of open space extending into the urban area, aren't they? You can see it perhaps more clearly on the broader scale plan, albeit the buildings are obviously very, 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 very small.
Yeah, I mean, it varies, according to the different areas that are designated, I think, as to what extent they're finger shaped. They're not all, I wouldn't say they're all of that ilk.
No, exactly.
Some are.
Exactly. Some are. Some meet the purpose of preventing coalescence. Some meet the purposes of being fingers into the urban area. The area in which the appeal site sits on the inset map is up here. You can see that. That's Farnham Castle. Again, you've kind of got to read it at the same time with the larger scale plan as well. It doesn't look to be, at least to me, but I'd like your views, please. Is that an open area of land that stretches into the urban area, or does it prevent coalescence?
I think there's areas there which do extend to a degree. Certainly alongside the urban area, I think it's the university campus shown, and the finger of land next to the castle. There's
sorry,
yeah,
let's have it clear. That finger,
yeah.
you would say, extends into the urban area, does it?
To a degree,
Yeah.
And then there's to the western edge of the
This
designation.
bit down
it
here.
sort of comes around the side of the
Yes, okay.
yeah. So yeah, it's not particularly finger-like, but there's an element of extending in. Also taking account of the sensitivities of Farnham Castle adjacent.
Okay, but on that basis, and I think I would agree with you, Mr. Sampson, that part of the appeal site, to the extent that it sits into the ASVI, that part of the ASVI is meeting the other purpose, i.e. preventing coalescence, isn't it? That's its purpose insofar as it sits on top of the appeal site. It's not a finger stretching into the urban area, is it?
I would normally expect, if the purpose was coalescence, for the gap between urban edges to be more marginal than it is here. There is still land to the north before quite some distance before reaching any further urban edge. So I don't think it's as clear cut as saying it's coalescence the purpose of the ASVI here.
Well, that except for those two areas that you've identified, the finger from Farnham Castle which is then surrounded by development, except at its northern opening, and the area to the west, which you also identified, which has development around it. The logical conclusion is that the remainder of that, if it's not serving the purpose of extending into the urban area, the only other purpose, in accordance with the purposes set out, is that it would be preventing coalescence.
Yeah, I mean, I think this particular ASVI is principally taking on board the particular context of Farnham Castle and the views of the church that we've heard about and so forth, as well as the small fingers and the fact that it's intertwined with the edge of the urban area at that point. So a sense of preserving a sense of openness of the landscape at that point, I think would take account
But
of.
that's not a purpose. We've established what the purposes of ASVI are, and I'm trying to understand, and we're all struggling to some extent because there is no individual assessment of why each of these areas identified as ASVI, which are the purposes they serve. So, but that's why I'm testing this with you. And it seems, at least to me, Mr. Sampson, that the appeal site, to the extent it sits in the ASVI, it's not an extension into the urban area. It's not preserving openness in an area which is surrounded by built-up development. The fact that it's got Farnham Castle next to it is neither here nor there. That's not part of the purposes. So it can only, that part of the ASVI on which the appeal site sits, it can only be preventing coalescence.
I find it curious if that was the case because of the reasons I mentioned, given the lack of proximity to an urban edge further north. It doesn't seem to me to really occupy much of the gap between the northern edge of Farnham and any development further north. So that doesn't seem to make sense to me, that the purpose of the ASVI here is to prevent coalescence.
Well, I mean, you've agreed with the appellants, and you've agreed because you've considered it, as to whether or not the ASVI and the development of the ASVI by the appeal proposal would result in coalescence between Farnham and Hale. So you obviously thought, well, would there be coalescence between these two settlements, Farnham and Hale? And you've concluded in the context of ASVI that it wouldn't. So you have thought that it would be serving that purpose, because if it wasn't serving that purpose, it wouldn't have been necessary to consider whether there was going to be coalescence.
I'm not aware that the reasons for refusal certainly don't mention coalescence.
I'm not asking you that.
It's not the reason that we're here today, as far as I'm aware.
We're not answering my question. You're diverting well away from my question.
I mean, if there's anything that is preventing coalescence between, it's the urban edge and the AGLV to the north, I would suggest.
Well, there's no case, I mean, if that is your answer, that it's not, when they talk about coalescence, it's not talking about coalescence of settlements, it's talking about coalescence of a settlement and a landscape designation. There's no case being made by the council that there would be coalescence between those two areas. You see, the point I'm really, you've understood the point. If this part of the ASVI's purpose is to prevent coalescence, you've agreed there is no coalescence. There is no case in relation to there being an impact on the ASVI, is there?
I don't think it's as clear cut as that, as I say.
All right. Okay, well, let's move on. Can I ask you, please, to, just before we move off the LPP 2, can we just turn up, please? Turn to page 34. And that's.
Which document, sorry?
It's LPP 1, so the local plan, CD 5.1. It's in that hard copy if you prefer it. Just go back a few pages, go back to the the pink tab. And just behind the pink tab, and then if you turn internal page 34, left-hand side, SP1.
Seems to be some pages missing from the printed copy. I can call it up, I think, on my computer.
Okay.
Go back, go over here.
They may be in different order. I can see now that my page 34 sits between 128 and 216, but page 34.
Page 34 of LPP1, yeah. Okay.
Yeah.
Yeah, I'm there, thanks.
And again, general question here. Policy SP1 and policy SP2, these are the primary spatial strategy policies, aren't they, in the local plan?
Yes.
So they are the ones that are looking at where in principle development should be located.
Yes, I wouldn't disagree.
And again, I don't want to trawl through all this. We can just note 5.10. This is reflecting what I said in the opening statement. There are 5 categories of settlement, the highest order being communities with key services, and they include Farnham. Yeah.
Yeah.
Ditto 5.15. National policy on the location advantage driven by the principles of sustainable development. And we've already agreed that both Farnham is a sustainable settlement and indeed the appeal site is a sustainable location relative to that sustainable settlement. So in policy terms and in principle, you and I agree, don't we, that the appeal site and the development of the appeal site for housing is in principle acceptable.
No, I don't agree that it's acceptable in principle.
There's no case being made by the council that it's contrary to SP1, is there?
SP1 does say planning applications that accord with the policies in this local plan and where relevant with policies in neighbourhood plans will be approved without delay, unless material considerations indicate otherwise.
Okay. My question, no case being made by the council or you that the proposal is in conflict with SP1? It's not identified in the reasons for refusal. It's not identified in your proof of evidence.
I mean, I don't take SB1 as being a prohibitive policy. It's encouraging sustainable development subject to the provisions of the local plan and the neighbourhood plan. In this case, there's a conflict, as we know. We argue with the neighbourhood plan. I think that's agreed between the parties, that there is a conflict with the neighbourhood plan. The extent to the conflict may be different, but the policy there, I don't see as being as I say, prohibiting development as such, but it does point out it sort of closely mirrors the MPPF, really.
It is directing development in Waverley to particularly sustainable locations. So if it was the council's case that in any way the development of the appeal site was not in a sustainable location, bearing in mind the council's spatial strategies, it would have said it is in conflict with SP1. But that is not a case that has been made, is it?
I agree, it's not mentioned in the reason for refusal. I don't think it's necessarily compliant either. I think it's one of those points where it's encouraging development in sustainable locations. That doesn't mean that development will be acceptable in every location that's sustainable.
Well, that's you're moving on to the specifics. I'm talking about the principle of development. Yeah. And insofar as the principle of development is concerned, there is no difference between you and I that the appeal site, in terms of its principle, is an acceptable site for housing development.
I'm not sure I agree with that because of the clear conflict that we've identified with the neighbourhood plan and taking account of paragraph 14.
Okay, well, we'll come back to those as well. I'm just looking at the spatial strategy set out in the local plan. SP2, which is on page 39. Again, no issue has been taken by the council or by you that the development proposals are in some way in conflict with SP2, have you?
So we're on to SP2. Sorry.
Yep.
Yeah.
These are the two spatial strategy
I'm
policies.
aware of the policies. Yeah, no, that's fine. In our evidence, I think we mentioned that the other paragraphs of the document certainly of LPP2 should be looked at as well. It's 3.5.
You're moving off. I'm talking about the principle SP2. No case by the council or you that the proposal is in conflict with SP2. Is that a yes or a no, please?
It's open to interpretation.
No, it's not.
It is.
Open to interpretation. Is the council making a case? Because if it is, I haven't seen it yet. And are you making a case that the development proposals are in conflict with SP2?
I'm looking at point 2 of SP2, where it does focus development at the 4 main settlements. There's then footnote 3, which says for the purpose of the policy, the built-up area of Farnham includes Badshot, Lee, and the built-up area of Hazelmere includes Beacon Hill and Hind's Head. So that suggests to me that growth is focused on Farnham as far as within the built-up area boundary and on allocated sites, which in this case are through the neighbourhood plan.
Where in your evidence do you put forward a case that the development is contrary to SP2? SP2, I'm not talking about the neighbourhood plan or any other policies. SP2. It's not in the reasons for refusal.
No, except it's not stated in the reason for refusal.
Where in your evidence do you say and assess the development proposals against the spatial strategy policy 2?
Just bear with me. I would like to turn to my proof. So 2.11 of my proof, it says the appellant suggests at 4.16 of their statement of case that as the appeal site is adjacent to the policy boundary of Farnham, recognised in policy SP2, that it is in broad accordance with the overarching spatial strategy of the plan. However, whilst Farnham is undoubtedly a focus for development, development beyond the settlement boundaries is considered to be contrary to the development plan.
Yeah, but that's a reference to FNP 10, because that is the only policy that sets a settlement boundary for Farnham. SP2 does not set a settlement boundary, does it?
It refers to settlement boundaries.
Sorry, SP2 does not set a settlement boundary for Farnham, does it?
It doesn't set the boundary, it refers to it.
No. Well, it doesn't. What it says, it focuses development at, doesn't say within Farnham, it says focuses development at. That's what it says in the policy.
It says at, not adjoining or near to, and it does have footnote 3, which refers to the built-up boundary, the extent of the built-up boundary of Farnham. So it does acknowledge the presence of the built-up area boundary, and indeed the proposals, other parts of the plan refer to the fact that if neighbourhood plan situations change, that the adopted policy map would be updated accordingly. So it delegates the boundary to, in the case of Farnham, it doesn't with other settlements. In other settlements, it does make allocations, but in the case of Farnham, it effectively delegates the boundary matters to the neighbourhood plan.
All right. So just so that I'm clear, I mean, the first issue for the inspector, identified by the inspector, was whether or not the development is in principle, before we get into the details of the impacts, etc., in principle, whether it's a suitable location. Can I just have a clear answer from you? I mean, there is no analysis in your proof of evidence. It's not reasons for refusal by the council that the development is in conflict with SP1 and or SP2. What is your position in terms of that first main issue? Is this, in principle, a suitable location for this development?
No.
And is that because you say it's in conflict with FNP 10 rather than because there is no analysis of SP1 or SP2? Is that the case? It's because it's in conflict with FNP 10 that it's not, in principle, a suitable location?
I have included, as I mentioned, reference to SP2 in the proof, and I've said whilst Farnham is undoubtedly a focus for development, development beyond the settlement boundaries is considered to be contrary to the development plan.
Well, not development plan as a whole, or one policy of the development plan?
Well, both.
Well, because it's in conflict with one policy in the development plan, it is, in your mind, by definition, in conflict with the development plan as a whole.
Because it, in terms of the LPP2, does not allocate residential development to Farnham. It delegates that duty to the neighbourhood plan. It's very clear on that. Other settlements are included with allocations within the plan. But in the case of Farnham, very specifically, it does actually delegate, in effect, the sites to be allocated for residential development entirely to the neighbourhood plan.
Well, no, it doesn't, because of course Coxbridge Farm is a strategic site.
In LPP1.
Biggest strategic site in LPP for Farnham.
In LPP1.
Yes.
Yeah, that was already pre-existing,
Yeah.
obviously at the time of the neighbourhood plan. So, and we've acknowledged that in the table.
Yeah, I appreciate that. But to the extent
yeah.
you say that it delegates everything to the neighbourhood plan, it clearly doesn't.
With the exception, I accept that, with the exception of the pre-existing allocated sites under a previous version of the plan.
And the single largest site in Farnham.
Yes.
Yeah.
Yeah.
Can Can I move on, please? Can I ask you please to look at LPP 2, which is at CD 5.3 in its hard copies as well, if you want to. Possibly that dark pink tab in the hard copy.
Yeah, which page, please?
Internal page 14 of LPP 2. And it's policy DM1, environmental implications of development.
So 40.
Might find it easier to get in
It's
the
okay,
hard
I've got,
copy.
got it on here.
Internal page 14,
14. All right, thank you.
policy DM1.
Yeah, on there. Yeah, thank you.
Development should avoid significant harm to the health and amenity of occupants of nearby land and buildings and future occupants of the development, including by way of an unacceptable increase in pollution, light, noise, dust, vibration, odor, or an increase in flood risk if significant environmental impacts from development cannot be avoided or adequately mitigated, or as a last resort compensated for, the planning commission should be refused. Now, I appreciate that there may be a difference in terms of what the level of harm is, but the policy test is that it's only if there is significant harm to the amenity of existing residents that there is then a conflict with this policy, correct? So some harm is not enough. It has to be significant harm. Yep. Good. And then the other policy, development management policy, DM5, which is on page 26 of internal page 26, same document.
Yeah.
This is looking at something slightly different. So DM1 is the environmental implications of development. DM5 is safeguarding amenity. Development should avoid harm to the amenity of future occupants and existing occupants nearby land, including by way of overlooking, I appreciate these are examples, but overlooking loss of daylight or sunlight or overbearing appearance. So these are, as it were, the property-specific impacts as opposed to the more general environmental impacts that are reflected by DM1.
Yeah.
And I mean, we agree, don't we, that there is no case being made by the council that the development would result in overlooking loss of daylight, sunlight, or an overbearing appearance. There's no case being put forward on that basis.
That's correct, yeah.
Okay, good. Right, then let's turn to FNP 10, please. So this is document, it's the neighbourhood plan, CD 5.5. And it's on internal page 44.
Yeah, got that, yeah.
This does a number of things. It sets, in effect, a built-up area boundary, settlement boundary, defined on map A.
Yeah.
Yeah, it gives priority to protecting the countryside from inappropriate development.
Yeah.
And then says that development will only be permitted where it would, and then it's required to meet 5 criteria.
Yes, that's right.
And I think the relevant criteria in this particular case are A, which allows for certain exceptions. We don't need to go into those. We don't fall with any of those. And E, enhance the landscape value of the countryside. And where new planting is involved, use appropriate native species.
Yeah, that's right.
Okay. The issue between us is The council says it doesn't enhance the landscape value of the countryside. There isn't any issue about when new planting is involved using appropriate native species. So it's simply that first point. Does it enhance the landscape value of the countryside?
Yes, in terms of E, yeah.
Yeah, okay. And I don't want to spend, say, much more time on that. Now, what I do want to look at, please, is just take up your proof of evidence. And I'm going to use your summary proof because that's the document that, or parts of it that were read out. And first of all, paragraph 4.8. So this is where you said in the second sentence, the appeal site is an area of pleasant open countryside, assists in defining the character of Farnham and its setting, and is designated as an ASVI for this reason, i.e., because you say it helps to define the character of Farnham and its setting. But we've established that's not actually a purpose set out in the LPP 1. It's not a purpose of ASVI at all, is it?
Except in the wording that you pointed out that it was more restricted, yeah.
4.10, this is where you're relying on Mr. Petro's evidence. And what you say in 3 lines in, while some boundary planting is proposed and some new hedgerows provided, he considers, that's Mr. Petro, it is unlikely this would be successful in concealing the development from the public footpaths and the wider ASVI landscape. Then you went on to say this, the proposals will lead to direct, permanent, and initially high adverse landscape effects on the application site, 1, and high adverse effects in 2 of the 3 landscape character areas the site is identified as being within, and interpreting that is LCA4 and LF6. So you understood, Mr. Petro, to be undertaking analysis of 3 different landscape receptors, the appeal site, and then 2 out of the 3 landscape designations, i.e. LF6 and LCA4. That was your understanding, wasn't it?
Yes.
Yeah. And what you were saying, and you were relying on his evidence, that in addition to the impact on the appeal site, there were high impacts on LCA4 and LF6.
Yes.
Now, of course, Mr. Petro's changed his evidence on that, hasn't he?
Yes.
Yes. But you did understand him to be looking at these as separate and discrete landscape receptors.
Yes, I mean, they're different characteristics, yeah.
All right. Well, that's a significant departure from the position because of the 3 landscape receptors, he has now moved to the position that is set out by the appellant in relation to LCA4 and LF6. So we're down to the impact on the appeal site itself. That is a material change,
that's not
isn't it?
entirely accurate. The appellant's evidence is that there are impacts.
Well, I said it has agreed to the impacts that the appellant has assessed.
Yes, which are that there are impacts on the wider character area.
Yes, but we know what those impacts are. But that is that's not my question. That is a significant change in position by Mr. Petro to go from a high level of impact, both at year 1 and in year 15, he says, to the position that the appellants have set out on LCA4 and LF6.
So what was the question?
Yeah. That is a significant change in position by Mr. Petro to move from a high level of significance of impact, landscape impact on LF6 and LCA4 to the position that is set out by the appellant?
It's certainly a change of position, yeah.
It's a significant change on the landscape impacts, isn't it?
It's certainly a change. I mean, I'm not really, I'm not a landscape specialist, so I can't really comment on the significance of that. But in terms of the overall, in terms of the points that I've made within my own evidence, I have noted multiple footpaths, both crossing the site and meeting at the northwest corner.
That's a separate issue, Mr. Sampson. That's not about the landscape impacts. Talking about the landscape impacts, that is about the visual impacts. So let's try and keep to the question, please. The landscape impacts. It is a significant, I'm going to only put it once more. It is a significant change of Mr. Petro to move from a high level of significance to the landscape impacts on LCA for LF6 to restrict his views on the high levels of impact to the appeal site. And that is a significant change, isn't it?
As I say, it's a change. I'm not going to offer my view on how significant that's for.
I don't see how you can avoid that with respect, because you rely on his evidence, and you rely on his evidence in the weighting table that has been agreed. So can you turn that up, please? Inquiry document 7.
Yeah.
And it isn't numbered, but in the disbenefits part of that table, so that's on internal page 4, if it had a number. Have you got it? Disbenefits. The first disbenefit that's identified is landscape harm. I think these are your words. Permanent direct adverse impacts on the appeal site and the wider character area in which it sits by reason of extensive built development. So that's LCA 4 and LF 6. And you gave the impact on appeal site LCA 4 plus LF 6 significant weight. But that was, of course, based on Mr. Petro's view that there were high impacts, high significance of impact on the landscape as set out in his original evidence. Correct?
Yes, I mean, first of all, it wasn't just prepared by me, this table. It was by the LPA appeal team.
Okay. Right.
So just to make that point, in terms of that disbenefit cell there does combine the wider effects, as I'm reading it, with the wider character effects and the appeal site effects. So in other words, it's not
exactly.
It's not split.
No, it hasn't. No, exactly. That's my point, Mr. Sampson. In arriving at a significant weight to be attached to that disbenefit, you have relied on what Mr. Petro originally said, namely that there would be a high impact, landscape impact on year 1 and year 15 on the appeal side, but also a high impact on LCA 4 and a high impact on LF 6. But we know that there's been a change to his evidence in relation to that. So my question is, clearly, having moved his position in relation to 2 out of the 3 landscape receptors from a high position, inevitably it is going to have an impact on the weight to be given to that disbenefit. Correct?
I mean, in terms of the appeal, the two elements here. One is the impact on the wider landscape character areas.
Mm-hmm.
One is the effect on landscape
Mm-hmm.
at the appeal site. So I don't believe the position has changed regarding the appeal site impacts. We're talking about the wider character area impacts.
Yes.
So this overall weighting is combining those two.
Yes, I know. You've already
Um,
said that.
So reduction of one doesn't necessarily
Well, it's
automatically
not just a
follow,
reduction of one. It's a
of one of
reduction.
the elements.
It's not just a reduction of one element. It's reduction in relation to two out of the three elements that are in this basket. Character area LCA4, character area LF6, where he has moved from being a high impact to the appellant's position. He has only maintained his position in relation to the appeal site.
Yes.
Yeah.
Yeah, no.
Are you suggesting that that change in position by him doesn't impact at all in terms of your assessment of the significance of that disbenefit, of that basket of landscape impacts?
The sort of visual envelope of the site in the broader landscape is limited. So the significance of the effects within the site, I think, are greater than the broader in this particular case because of the limited visual envelope and beyond because of the topography. So I'd give greater weighting in terms of the overall weight to the appeal site landscape effects than the other. So it doesn't automatically follow, in my mind, that the reduction of the broader position in terms of weight would necessarily reduce the overall.
But I don't see anywhere in your evidence that you have given weighting, additional weighting to the impacts on the appeal site as opposed to the broader area. That's not the way this is structured, neither in your evidence or this table. They are treated equally. You rely on a high impact as assessed by Mr. Petra originally on LCA4 and LF6 and a high impact on the appeal site. But he no longer maintains that there is a high impact on LCA4 or LF6. And there's no distinction between those areas in terms of weighting in your evidence, is there?
Paragraph 4.1 does refer separately to impacts on the application site in terms of landscape impacts. 4.10 as distinct from the landscape character areas. So it does acknowledge that there are two separate, if you like, matters within that overall landscape matter. Except it doesn't. It does separate them out in terms of the effect on the wider landscape and the site-wide landscape.
Yeah, and it doesn't say I attach greater importance to the impact on the appeal site as opposed to the wider character areas. It doesn't do that.
Okay, I accept that.
Yeah, thank you. All right. Can we again just move on, please? In terms of the amenity impacts, again, just using really your summary proof as a reference point. 4.20 or 4.19 and 4.20. The concern here, particularly from traffic, appears to be largely limited to the northern end of Keepsake Close. Is that correct? You say that twice. At 4.19, the northern end of Keepsake Close will become through traffic, and then at 4.20, given the properties at the northern end of Keepsake Close will currently not experience traffic, there will be a significant change.
I think, as I mentioned earlier in examination in chief, that was where I felt the impact would be greatest.
Yeah.
Yeah.
And I think you referred to that as being about a half a dozen of properties or so.
Not quite.
Well-
So just to be clear, at the very northern end, on the private driveway, there's half a dozen properties or so.
Right.
Where they obviously by definition would not experience through traffic.
Yeah.
There are then some properties towards the northern end of Keepsake Close that are beyond to the south of that private driveway, which I think would still be significantly affected. I think we heard from one of the residents concerned yesterday of one of those properties to the western side of Keepsake.
I'm more interested in your evidence than their evidence.
Well,
Give me a number.
Yeah.
If it's not half a dozen, how many are we talking about?
Let me just turn up a plan, if you don't mind.
Sure.
Which plan are you referring to, Mr. South?
Oh, apologies, Inspector. It's I'll try and find the reference. Bear with me. It is 17. Yeah, that's right. CD 2.17, madam. Yeah. So this is the plan produced by Motion Highways consultants, setting out the highway works, the widening and so forth, which is quite helpful just in showing the properties within Keepsake Close. I think we're all familiar with Keepsake Close, where that is.
Yeah.
So what we can see at the northern end, you've got the private driveways. There's going east to west, 1, 2, 3, then a pair of semis, 5, 6, and I think the end one, 7 properties that are accessed directly off the very northern end. You've then got 2 further properties to the south of that, which are very close to the road frontage.
Are these the properties where you've got just under the legend, relocate visitors car park?
Yes, that's right. That's right. And then on the left-hand side, there's a 5.5 metre notation. Just under there, there's a property which has its front door and front windows
That's no longer the northern end of Keepsake Close. That's the southern end of Keepsake Close.
the Keepsake Close goes further down, I believe.
Okay. So where do you draw the line for
Yeah.
northern end of Keepsake Close?
Fair question. Yeah. I would suggest to the beyond. There's a junction on the left. I haven't got the road name there. So I would discount between Cascade Way and that first turn off to the left in terms of northern end of Keepsake Close. So I would say beyond the 2 junctions going off to the west and the east.
All right. So what is that? Is that 7 plus 8, 9, 10?
Yes, I would say 10.
10?
10 properties.
Okay.
Yeah, we can agree. Yeah.
All right. Thank you. And yeah, and I think you've accepted that at least in terms of replacement trees, that a concern, I think, expressed by members that there would be a loss of trees isn't in fact correct, because the trees can be replaced. I think not only replaced, but increased in number.
We've accepted the replacement tree planting as being achievable, so that's not a point we're taking.
No. And I think you did say, though, it would take some time for those to grow. If you have the tree replacement plan, which is Appendix 3, isn't it, to the Statement of Common Ground, Landscape Statement of Common Ground.
Have you got the CD number at all?
Statement of Common Ground CD number is 8.4. Thank you, madam. It's Appendix 3 to that document.
3. Yeah.
And there are, I appreciate you not taking a point about impact on trees, but if you look at the legend, these are not whips or saplings, are they? They are advanced nursery stocks, semi-mature, heavy standards, and extra heavy standards. These are quite considerable trees that are going to be put in.
Yeah, sorry, on the top left of the
Top left,
plan.
yeah, there are two
um,
sides to it because it deals with two parts of Cascade Way.
Yes, I see. So we've got yes, a mix of semi-mature, heavy standard. What I haven't got is the numbers of each, but there's a range of different standard trees there. Yeah.
Yeah, these aren't whips or saplings that perhaps the existing trees on Cascade Way and Keepscote Close were put in as. These are already pretty advanced trees.
Yeah, can't disagree.
Yeah. Okay. Thank you. Right then, I think there's just one other matter I wanted to ask you about, and that is paragraph 14. I'm not going to debate with you the interpretation of the other paragraphs, 69, 70, etc. You accept, though, that paragraph 14 in the NPPF introduces a rebuttable presumption, doesn't it? Do you understand what I mean by that?
Rebuttal presumption being a rebuttal to 11, paragraph 11.
Yes, it's a rebuttal to a rebuttal.
Yes, yes, yes. Again, I can't disagree with that. I think in the opening remarks, Mr. Green, his summary made clear our interpretation of that, of the effect of para 14 and what it does.
Yeah.
Yeah.
But we agree it is a rebuttable presumption. In other words, it's not an absolute. So it's not saying that if there is a conflict with the neighbourhood plan, thou shalt refuse. It says if there is a conflict, that is likely to be a significant demonstrable impact, which reverses the presumption in paragraph 11.
Yes, and it's worded sort of the other way to paragraph 11.
Yeah, exactly. Which means, of course, that as a rebuttable presumption, there will be cases where the facts of that particular case mean that either limited weight or no weight should be given to paragraph 14.
Sorry, repeat the question.
Yeah.
There'll be cases where
Because it is a rebuttable presumption,
Yeah.
there will be cases where the facts of that particular case mean that either no weight or limited weight should be given to paragraph 14.
I would argue that where para 14 applies, it's likely to be given weight. Now, the question of the level of weight is obviously,
Yeah.
a matter of debate. But the fact remains, para 14 remains in the December 2020, the latest version of the NPPF, the December 24 version. It would have been totally within the remit of the government to have deleted that paragraph, should they have wished, but it remains.
And I'm not disputing any of that. That's not my question.
So, but the fact that it remains, and that it's the 5 years figure in terms of rather than the lower figure in the previous version, means that the weight that to be given to it, in my view, is not to be ignored. And obviously,
I haven't turned to the factors that might cause you to do that. I'm just trying to establish a principle. You agree with me that as a rebuttable presumption, there will be cases where that presumption is set aside because of the particular facts of that case. I think that's a proposition. I would have thought that was uncontroversial.
I mean, if A and B aren't met, then
No, I'm not talking about if A and B are not met, then it doesn't apply at all.
Agreed. Yeah.
Yeah, I'm not talking about that situation. I'm talking about a situation where A and B are met.
Yeah.
Okay. But even if A and B are met, because it is a rebuttable presumption, there will be cases which on their particular facts mean that limited or no weight should be given to that presumption.
I'm not sure I follow. I think the paragraph 14 is there for a reason.
Yes.
It's
We're
not just
not
there for the
disputing
sake
that,
of it.
Mr. Sampson.
I don't quite follow that, you know, why is it there if it's to be ignored?
Okay, let me put it another
yeah,
way.
yeah.
Are you suggesting to the inspector that there will never be an occasion when you can't give limited or no weight to paragraph 14, that it always has to be given full weight? Is that your position?
I wouldn't say it was always has to be given full weight, but that's different from ignoring it. Yeah.
In what circumstances might it not be given full weight?
In terms of the other balancing points, you know, within the planning balance, obviously there is a balance to be struck. With that, I do accept that, but I do feel that it's there. Like I say, it's there for a reason, shouldn't be ignored.
Yeah.
But
Okay.
yeah.
Well, making some progress. So you do accept that some of the factors that you say go into the general planning balance might have an impact in terms of what weight you give to paragraph 14 on the assumption it applies. Okay.
Yeah, that's
Well, let's just look at some of those then. You agree with me that it is relevant in determining what weight to be given to paragraph 14 if the local authority cannot demonstrate a 5-year housing land supply.
Our position is that the provision that we're within the 5 years, and the correct way of reviewing the neighbourhood plan and the sites around Farnham is through the plan process.
I'm not asking that question, please. I really am trying to focus. You have accepted that there will be some factors, which you referred to generally as being factors in the planning balance, which might be taken into account in reducing the weight to be given to paragraph 14. That's where we're starting from, okay? Yeah, that's your position.
Yeah.
Yeah.
Right, yeah.
Good. So I'm now just trying to examine what those factors are, and I'm putting to you a series of factors that might go into the weight that you give to paragraph 14. The first factor is the fact that the council does not have a housing land supply. That is a factor that goes to the weight to be given to paragraph 14, isn't it? We can have a debate about how much weight, but it is a relevant factor that goes to the weight to be given to paragraph 14.
I mean, as I would see it,
Yes, start with yes or no.
the paragraph 14 is the starting point.
Sorry,
and-
Mr. Sampson,
yeah,
I appreciate this.
Yeah.
It is accepted that it's helpful if we start with a yes or no and then caveat.
Okay.
Thank you.
Is it a relevant factor that goes to the weight to be given to paragraph 14?
No.
Right, then I'll move on. I'm going to submit that you're wrong, but I'm going to move on. Is the fact that this neighbourhood plan is on the cusp of being more than 5 years old, is that a relevant factor?
No.
Is the fact that the position in relation to affordable housing, as bad as it is, it is the under-delivery of affordable housing relevant to what weight you give to paragraph 14?
Is the extent of affordable housing needs?
Is the under-delivery of affordable housing relevant to the weight to be given to paragraph 14?
No.
Is the fact that there is no immediate plan or proposal by the council to address its under-delivery of affordable housing or its housing land supply a relevant factor going to the weight of paragraph 14?
No, as per the weighting table that we've prepared.
No,
Yeah,
I'm not
like to
talking
qualify
about the planning
so
balance
sure,
now. I'm just
yeah,
trying to
yeah,
understand
yeah.
whether these are relevant factors that go to the weight to be given to paragraph 14.
No,
No?
because para 14, as
Okay.
per para 14, it's considered up to date within the wording of para 14.
Right.
Yeah.
Well, then help me.
Yeah.
What are the factors? What are the factors that you have accepted that go into the planning balance that would go to the weight to be given to paragraph 14?
Okay, just to be clear, I wouldn't affect the weight I give to para 14. It would be the weight I would give to the other factors against para 14.
I simply haven't understood that. We started this because you accepted that there would be factors that you would consider in the planning balance which would be relevant to the weight to be given to paragraph 14. Now you've struck out everything that I have put to you to date. So what factors would you consider to be relevant to the weight to be given to paragraph 14? What are they? Not in the planning balance now. What are the factors relevant to the weight to be given to paragraph 14?
As far as I can see it, it's a straightforward paragraph.
No, you're
There's
avoiding
two
the question.
criteria, it's A and B.
Yeah.
It either applies or it doesn't.
No, we've moved on from
that's
that.
my-
Mr. Sanson, we really have moved on from that. This is, as you know, this is on the basis that A and B are met, and therefore
Right.
it applies. If
It
A and B are
applies,
not
yeah.
met, we don't get
If
into
it applies,
a
it
debate. Sorry.
applies.
We
Yeah.
don't get into a debate about
Yeah.
what weight you give it to it.
Yeah.
Because it applies. But because it doesn't apply at all. But if it applies, you've accepted that there are some factors that go to the weight that you give to paragraph 14. You've struck out everything I've put to you. So what is left? What do you say are those factors that go to the weight to be given to paragraph 14 on the assumption it applies?
I just disagree with how you're applying paragraph 14. Because looking at paragraph 14, just to recap on what it actually says, it says that in situations where the presumption at para 11D applies to applications involving the provision of housing, the adverse impact of allowing development that conflicts with the neighbourhood plan is likely to significantly and demonstrably outweigh the benefits.
Yeah.
So
likely to.
So what it's saying is that there's a presumption against development in para 14 rather than presumption in favour.
Yeah.
So where that applies, what I'm saying is that there has to be enough other material considerations, such as, you know, the various benefits and so forth, to significantly and demonstrably outweigh the harm.
I agree with you that it is necessary then to consider where it applies, whether there are relevant considerations that go into that equation. Now, you've struck out all the relevant considerations on the basis they are irrelevant. So I'm trying to understand, and you've accepted that it's a rebuttable presumption. It isn't a absolute prohibition. There are circumstances, plainly there are circumstances, that even where it applies, you don't attach full weight to it to say, that is what it says. It means that there will always be significant and demonstrable effects which disapply paragraph 11. I just want to understand from you, because you've accepted that there are factors. What are they?
Okay. Well, right. Let's rewind slightly then. So if the neighbourhood plan in question wasn't the vehicle through which residential development was allocated in and around a settlement, then, and the primary vehicle for doing so, then that could reduce the weight. But in this case,
then it wouldn't have allocated sites meeting its need. It wouldn't apply at all. It wouldn't meet criterion B.
Well, there can be sites allocated, but in our experience, the amount of development that is allocated through the neighbourhood plan here is significant.
No. You've put to the inspector a premise which, if the neighbourhood plan doesn't allocate the development that is needed, that might be a factor that goes to the weight. But that's wrong, because if it doesn't meet the identified need through allocated sites, paragraph B means is not met. It doesn't apply at all. So it doesn't work, I'm afraid, Mr. Sampson.
Well, as I say, the paragraph, to me, the starting point is it applies or it doesn't. And then it's the other factors that will result in the weighting against 14. Quite simple. I mean, I don't understand why that's, particularly contentious. In each case, it's a question of weighing up the other factors against the presumption in the plan-led system of the development plan. So, yeah.
And so that's the point. So that's what I'm asking you. Let's put it in your terms. What are the factors that weigh against the presumption in paragraph 14?
Yeah, so that's it. So the starting point.
No, what are the factors that you say
that weigh against
the presumption in paragraph 14? What are those factors, please? Because I've put 3 or 4 to you and you've said they're irrelevant. So what are the factors?
I think maybe just a misunderstanding of terminology here. My starting point is very simple. Paragraph 14 either applies or it doesn't, and that's the starting point.
Yeah, it applies.
So it applies. Yeah.
Okay.
So we agree with that. Yeah. So we're agreeing it applies.
Yeah.
Is that correct?
That's been the premise of my questions for the last 15, 20 minutes. As you know, it applies because A and B.
Yeah.
That's not our case, but that's the assumption that is being made here for the purpose of the question.
Okay.
It
Yeah,
applies.
it applies,
Okay.
Yeah.
So you have said that nonetheless there will be factors that go against the presumption in paragraph 14.
Well, the presumption is the starting point.
Yeah. So what are
but
okay?
unlike-
so what are the
yeah,
factors?
unlike
If it's the
11
starting point, what are the factors that take it beyond that,
So-
which set aside the presumption?
So unlike, as we've said, unlike 11D, the presumption is the other way. That's the starting point. Then you have to weigh the other benefits with the disbenefits to arrive at an overall balance. That's.
So, Mr. Sampson, sorry, so can I ask, just to possibly to rephrase it, because we seem to, because I think we're skipping around the same point round and round again. I might be wrong, I'm slightly lost, I think. But is a suggestion, Mr. Lisson, that you've had a number of points put to you about the fact that it's nearly 5 years old, is that relevant? And you said no.
No. Yeah.
Under delivery, affordable housing, and you said no. So there were sort of 4 or 5 points put to you in terms of those being issues, and so therefore are they relevant? So could I phrase it a slightly different way? What benefits might the appellant be putting forward that would make it relevant? Is that it, in terms of what factors might there be in the scheme that push it the other way? Is that where you're going?
Set aside the rebuttable presumption in paragraph 14.
Yes. So if things like under delivery affordable housing, things like that are not something, what would there have to be applicable to set aside that presumption? I see where you're starting. I get that, and I think everyone else does as well.
I think what I'm saying is I wouldn't set aside the presumption, the starting point, but that the other benefits would then, like you would do, Adam, in a situation where 11D applies, that you would start off with a development plan, and then it's a question of the tilted balance, isn't it? And applying the different benefits, disbenefits. So all I'm saying in this case is that para 14, I'm saying is it applies or it doesn't as the starting point. Then beyond that, of course, all of the other factors which we've set out, I think in the weighting table, of course, that then comes into the overall balancing with paragraph 14. But what I say is that I don't disregard paragraph 14 as the starting point. So that's, I don't know if that.
Yes, Madam, I think the problem was it was suggested that somehow you give less weight to the whole paragraph. Actually, I think that the real issue is, assuming it applies, there's a balancing exercise. The paragraph starts with a presumption against granting permission. It says it's likely that the harms will outweigh the benefits. But in that balancing exercise, of course, you look at all the relevant factors. Housing supply, affordable housing, harm to landscape, all those factors go into the equation. I think the problem was the way the question was put initially, suggesting that you give weighting to the paragraph. It's, no, the question is what weighting you give to the exercise required by the paragraph.
Indeed, yeah, yeah.
So I think that's where the confusion arose.
That might be where I was getting lost, actually. Mr. Listeners, are you suggesting that you give less weight to the paragraph, or are you suggesting that that para 14 is there, and then the other considerations then essentially?
I'm
filtered?
saying there are two exercises, that if you look at paragraph 14, that a decision has to be taken as to what weight that you give to that particular policy. It's a policy, it's just a policy. And it's not an absolute prohibition. It is a policy that says it is likely to. So I think we accepted that that is a policy presumption that can be rebutted. And I'm trying to understand what factors would go into that decision about the weight that you give to that policy presumption.
Okay, can I?
And say, I mean, it seems to me that they don't necessarily have to be factors that are relevant to the planning balance.
Can I just interject?
So can I just give you an example? So the fact that this plan is on the cusp of expiring, although it is technically within paragraph 14A, if it was going to expire tomorrow, it seems to me there's a pretty compelling argument to say that, well, I'm going to give less weight to the rebuttable presumption against development being granted because this is going to expire tomorrow. So that's a relevant factor which doesn't necessarily go into the planning balance. Now, that's what I understood Mr. Sampson to be accepting. There were factors that go to the weight, and I'm trying to understand from him what are those factors that go to the weight.
Right, let's look at it another way, if I may. Paragraph 11 of the NPPF, we've got the presumption in favour of sustainable development, has a number of footnotes, which have the effect of significant features and so forth, heritage assets, areas of high flood risk, various factors, which make very clear where the tilted balance is reset. Now, in the case of paragraph 14, there isn't any such expansion of that policy to indicate where one should give a reduced weight to the paragraph itself. So I'm very clear. The wording is there. It's very clear. Either it applies or it doesn't. I'm sorry if that wasn't very as clear as it could have been. But beyond that, in the balancing exercise, the various benefits, disbenefits are taken into account. But I don't accept that para 14, the weight as a starting point should be reduced. You don't cherry pick unless there's a reason as per footnote 8 at paragraph 11D. You don't just sort of make it up on the spot as to what weight you give to it. There's a reasoned methodology there. Para 14, I think the starting point is very clear. If there are then other factors that come into play and do outweigh it, well, that's the balance. But I don't think that the initial weighting given to para 14 should be reduced. There's no suggestion anywhere in the NPPF of a tapering exercise as it approaches the end of the 5-year period. If we did that, when would we start applying reduced weight? Is it after 4 years? Is it 4.5 years? This, if that was to be the case, why isn't that stated? The whole point of extending as I would interpret it, if you like, the period during which the neighbourhood plan applies would be to allow for time for the neighbourhood plan to be reviewed in order to properly deal with increased needs through the plan-led process. That would be my understanding, the purpose.
Well, I'm not going to take it any further. I mean, don't agree with you. Seems to me you've changed your position on this, but I'll make submissions about that. Can I ask you, though, please, to just come back to then paragraph 11D? The test in 11D2 has changed with the 2024 December 2024 version, because it has introduced, hasn't it, that when you are considering whether the adverse impacts would significantly and demonstrably outweigh the benefits when taken against the policies in the framework, when assessed against the policies in the framework taken as a whole. I think there was a full stop after that. The 2024 version has now introduced the requirement when undertaking that assessment to have particular regard to the key policies for directing development to sustainable locations, okay? And I mean, we're agreed, aren't we, that this is sustainable development, a sustainable location in terms of both the settlement plus the appeal site itself relative to that sustainable. So it is consistent with that, yeah? Making effective use of land. You're not disagreeing that the appeal doesn't make effective use of land, are you?
No.
No. Securing well-designed places. There's no case being made by the council that it doesn't secure well-designed places.
Well, I would disagree with that. I think the opportunity cost of releasing the site is to undermine the well-designed place of the existing development. That is significant.
I don't see any case advanced by you that releasing this land somehow has an impact elsewhere.
The whole point of reason for refusal too is that in order to obtain access to the site, you've got to widen the highway within the established
Oh, I
development.
see. Okay.
And therefore the adverse effects of noise, light from car lights,
Okay.
you know, all the rest of it that we've discussed. So I think in that one, it's degrading the existing environment as a result of obtaining access.
All right. And providing affordable homes, again, obviously you've got no issue with that.
Providing affordable homes. Yes, I mean, we haven't gone into the weighting afforded to the affordable housing. It's obviously a benefit. However, in terms of the total provided, 24, of which 6 will be first homes. And then there's a proportion of the balance which is affordable rented. So in terms of the positive benefits of the affordable, I would place it in that context, is that not all of the affordable will meet the local housing need.
Again, I don't understand there to be any complaint by the council in relation to the mix of affordable housing provided.
No, it's agreed in terms of that, yeah.
So when the revised NPPF says, when you are undertaking this paragraph 11D2 balancing exercise, in which it is for the council to show that the benefits are significantly and demonstrably outweighed by the harms, you have to have particular regard to 4 policy areas. And I think we're agreed that 3 out of those 4 policy areas are met in this case in favour of the development.
Yeah, under para 11D, yes, there's one obviously that I feel quite strongly about, and that's under 11D. It's not under paragraph 14. Of course.
I'm not talking about paragraph 14. I'm talking about 11D2. That the 4 particular policy areas that a decision taker is directed to have regard to, 3 out of those 4 are in favour of development on this site.
Yeah, I would accept that, but 11D, of course, is in the presumption in favour of sustainable development, which is changed by 14. So, yeah, I accept those things. I accept your recollection, your summary, but as amended by para 14.
Yeah. All right. Thank you very much indeed.
Thank you.
So you finished, Mr. Liston?
Yes.
Yes. Thank you. Right, I think everybody needs some lunch. It's 1:10, unless you particularly wanted to do re-examination now, but I think, are you happy to take a break?
Happy to take a break, madam.
I think so, good.
Okay.
So it's 1:10. Is everybody happy to come back at 2 and continue? That gives us just under 50 minutes or just over 50 minutes. All right, splendid. And we'll do any housekeeping when we get back, I think. I think it's time for some food. So we're adjourned until 2 o'clock. Thank you.